Okay. All right, I think we're good. Good morning again. So we have this morning this afternoon, a plain arraignment calendar that has a couple inquiries on there. We also have a sentencing. Is Mr. Willock here? Great. Good. We will do that this morning.
Chief Woody advised me yesterday that investigator Lewis, whom he would be meeting with, is only in the office today as well.
Okay. Because is this an ICOTS thing?
Yes.
Okay. All right. We'll do that, but let's call the calendar and figure out who is here and who isn't. So position one on the plea and arraignment calendar is Dexter McGriff. Mr. McGriff, you're here. Good. Your lawyer put in a leave for basically the remainder of 2025. Not okay. I entered an order last night saying can't do that. He is going to need to identify a week when he can be here for the trial of your case, if it's a trial, or if it's resolved some other way. So he'll be processing that order. You haven't done anything wrong. I don't want you to worry about it, but an attorney can't say, hey, see you next year, unless it's maybe the middle of December, and then that's okay. So I'm gonna work with him and Ms. Clark, and we will identify a week when we can let everyone know this is the week for the McGriff trial. If it's gonna be a trial, we'll do that. We won't have any, I can't get this witness here. And if it's gonna be resolved in some other way, then it will happen on or before that date. In the meantime, I think we had this on the calendar to figure out, was it an evaluation and the results of the evaluation?
The results of the evaluation, that was what was supposed to happen today.
Okay, Mr. McGriff, have you sat down with the doctor yet to have the conversation you were supposed to have, the evaluation? Okay, Ms. Clark, I know this hasn't been your project. It was requested by Mr. Schnipper. Are you aware of what, if anything, has happened?
The last that I was, knew that he was actually working to get that done. I know the state's ready for trial on the case, so.
Okay, so do you have any updates? No. I guess we can reach out. There is someone who is in for Ms. Green. I think her name is Bogle. Maybe we could ask her. Let's see. Chanel, Shanelle, Bogle. If you could reach out to her to see what her records say about an evaluation for Mr. McGriff. Mr. McGriff, I'm gonna have you take a seat. We're gonna see what we can learn about that. You were supposed to sit down with a doctor or a counselor or something because Mr. Schnipper asked that we get that taken care of just so everyone has complete information about your situation as well. And that kind of sort of should have happened by now, but again, that not necessarily on you unless you had appointments and you were missing those appointments. Was there ever a time when you were supposed to meet with the doctor and you said, nah, I'm gonna go do something else? Okay, all right, well, that's probably part of the issue. Okay, if you take a seat, we'll circle back to this case. All right, Marquise Sinkfield.
He's hired Beverly Taylor.
Oh, right. I have notes here. She filed a waiver, but no one was excused. But this is not your case anymore. It's Ms. Taylor's. All right.
I will reach out to him.
Okay. You can reach out if we can't reach Ms. Taylor. I didn't excuse Mr. Sinkfield, so I'd be inclined to do a bench warrant, but we'll do a little bit of outreach and see what we can learn. All right. Mr. Ailero?
He should be in custody, Judge.
Okay. Here's Miss Taylor. Hey, Miss Taylor.
Good morning, Judge.
Good morning. We just called your client, so we'll hold on that if you can try to reach out to Mr. Sinkfield.
Judge, that's fine. I've been on this case since October of last year when he was in non-complex, filing entry, discovery, waiver of arraignment. He was here, I'm getting the court notices on him. He was here in April. He was said he was told by the court I didn't represent him. There was nothing shown that I represent him, etc. He told talk to the public defender. I've been representing this man. I'm getting court notices. I'm just trying to find out what's going on.
Well, me too.
I got another notice for arraignment. We waived arraignment back in October on this spot, Judge.
Well, you know, when things get bounced from non-complex, it's not always clear to us what happened on that side of the equation, but I'm pulling the case up now. Let's see.
And I did, speak to him. We just didn't know why we still had to go on the arraignment calendar. My office emailed Ms. Nelson, everything. We didn't understand why we was being told I didn't represent.
Okay.
I had asked my office to e-file another waiver of arraignment on the case.
You did, I got it, but that doesn't excuse Mr. Sinkfield.
Okay.
So there are two waivers in. One was filed in non-complex. Looks like in October of last year, you filed an entry.
It's here in April that we had filed anything.
So, yeah, I don't know what happened in April, but we're here now. You're here, and we just need to get Mr. Sinkfield here, and we can stop the insanity. We'll just get a scheduling order in place. If you already have discovery, then we can fast track it to a final plea, et cetera. But most of all, we need Mr. Sinkfield. So if you could reach out to him and I'll even accept a Zoom appearance on his part. I just need to be able to lay eyes on him.
All right, Judge.
Thank you. Deputy Gordon stepped outside, so I don't know who's in custody. I'm not doubting you, Ms. Wood. But let's see when Deputy Gordon comes back. Oh, he's there. He dashes in. Is one of the people you have up for this morning last name Ailero? Okay, he's here. So we're ready for him whenever you get a companion. Oh, he's got two cases.
He has 3, Judge.
Let me keep going. He's got 3 cases. All right. Do you have all 3 of those cases, Ms. Wood?
Yes, Judge.
Great. It'd be great to handle him this morning then, so we get those 3 cases moving along. Look at that. Okay. Mr. Sinkfield, good morning. Let's go back to position 2.
Thank you, Judge.
All right. This will be quick. Mr. Sinkfield, I got an address for you on Lee Street in Decatur. That's a good address. You got your lawyer right there. She knows how to reach you. I do have a W on the screen.
And the judge does see where I did represent you. I was confused last time.
Yeah, I don't know what happened in April. I don't recall it. I know you had a court date, but Ms. Taylor came in this morning hot and heavy, letting me know she's your lawyer. It's in the system. She's your lawyer. No one's going to take her away. So she is your lawyer through the end of this case. And we don't have a whole lot more to do. If you feel, Ms. Taylor, like the discovery you received when this was in non-complex was the discovery. I know sometimes in that unit you get a police report And there's more to this case, given what the charge is, so,
I would like to state that and make sure that I have everything to send to the discovery, but.
Okay.
Those will find plea out there.
okay. We're just checking one thing.
If I need to file a motion, most likely.
Right, exactly. Will there be a scheduling order? So that's gonna set a deadline for the state to get you the rest of discovery if there's more, and then motion's deadline for you. We'll just have that final plea fairly soon. Okay.
Who's the AD on this case?
It'll probably be Ms. Davis.
Okay, good morning.
Good
Yep.
morning. Good.
Ms. Davis is new to the courtroom, not new to the law, just new to the courtroom. So that will be your counterpart. Should we have Gordon? All right, okay. Can you run this name, position 2? Thanks. All right, Ms. Davis, anything from the state in Mr. Sinkfield's case?
No, Your Honor.
Okay, it's okay if there's not. With plea and arraignment, I just always want to make, you may say like, oh, actually discovery is voluminous. It's going to take a while. Not this kind of case. Discovery won't be voluminous. Ms. Taylor, if you and Mr. Sinkfield can take a seat, we just got to check one thing on Mr. Sinkfield. Once we're done checking that, you two are excused. I promise no more arraignments for him. It will be motions or final plea. All right, so Martavius Gay is in custody. He's got a bunch of cases and a bunch of revocations. I think he's got 3 revocations from Judge Richardson that are here if we need to work through those. And then he's got this case for plea and arraignment, and then there's a case under judicial hold. Is that judicial hold case our case? Okay, busy man. Who is representing Mr. Gay?
I think he's gonna be mine, Judge. I do need to speak with him.
Okay, well, when we get Deputy 2 in the room, you can chat with him.
Thank you.
Sure. Mario George.
He's the same position, it's number 6.
Oh,
Him on.
oh, that is Mr. Gay? That's his AKA?
Yes.
Okay.
Who's co-defendant? Do you think it's a good?
Is there something different?
That's a different person?
Oh.
Okay.
I think Gay uses the same alias as George.
Well, let's look.
Because those are the same cases.
Yeah, but the 2 defendants listed in the docket. Let's look at the indictment.
We're looking for what she said.
It's 2 people.
Okay, so the allegation in the indictment is that Mr. George, a distinct person, mailed drugs to Mr. Gay while Mr. Gay was in jail. And so they are charged with a conspiracy to get drugs into the jail. So there are 2 different people. It may well be Mr. Gay has used that name before, but the way the state's charged this, we have 2 defendants. So Ms. Wood, you'll have Ms. Gay. That means Mr. George is not here. So we'll start with the bench warrant, but we'll also need to see if Ms. Cabrera will end up with that case. Do you know if they work on assignments when someone is in judicial hold, or they, meaning like Mr. Luemba and that team, or would they just not worry about assigning it now because there's no body?
I'll go ahead and just send Mr. Haddad the email.
Okay.
To get it started.
Thank you.
We'll see what happens.
Okay, we will. All right. Antonio Burden. I don't have waiver. Is Sarah Rosenhoover a name from your office, Ms. Wood?
Yes, sir. And if he shows up, I will need to just requalify him, but
Okay,
I have not had contact with him.
all right. Ms. Davis?
Judge would ask for a bench warrant and bond forfeiture subject to his appearance today.
Okay, definitely a bench warrant. Your predecessors rarely said the phrase bond forfeiture. I'm all for it. If, that's gonna be your gig, that requires some filings that are sequenced in a certain way. And if that's one of the things you bring to the table, I'm super excited. I have a couple colleagues who do it. I just have never really tried to force the issue. He's got a big old bond though, so, no reason we shouldn't try to forfeit it. We'll see how that part plays out, but at a minimum, we'll do the bench warrant.
Thank you, Judge.
All right, Malik Brown is in state prison. He's excused, but a waiver was filed, and it sounds like there's a motion to suppress that I'll need to take a look at, see if we set that down. So, and it lists Mr. Hiles. This is a gang case. That we were done with those. All right. So there's a waiver, we'll do a scheduling order, and we may have a motion. Okay. Jaman Willis. Hey, Mr. Willis.
Yes, Judge. Nelson Road person.
Hello, Mr. Rhodes.
This is an arraignment. We'll be waiting formal arraignment.
Okay. We have a waiver form for you to fill out. If you want to do that, and then if you just touch base with Ms. Davis, the prosecutor on the case, once you filled out the form and connected with Ms. Davis so she knows who her worthy opponent is, then you and Mr. Willis are good to go. Let me look his case up first. Oh, that's one of the things we're going to look up. Oh, you're a co-defendant with Mr. Brown. Okay. Yep. Okay. I see it's from Judge Ingram.
I don't know what it is, you know, asked hearings, but it seemed like, I don't even.
I can even print it out. I found it.
Oh. Because I was too young.
Deputy Gordon?
I'd be shot. Jammed. It was pointed. He cleared the jam.
I know, but I think I can hear him. He's just in there. Mr. Hiles,
Oh, Your Honor.
that's not very energetic.
Oh, Your Honor.
Yeah. Although I have to tell you, we were just not very energetic when we saw we had another one of your cases, so it's mutual.
Oh, don't worry, there's more coming too.
Good. So Mr. Brown, I just called, he is, not as in, I just called his name. He's in state custody. His lawyer has filed an entry, Mr. Bixson. He's filed a waiver and a motion to suppress. I need to look at it, see if it's particularized or if it's just one of these, hey, probably something should be suppressed in this case.
It's not particularized, it's very basic.
Okay, so there's nothing to say.
I read all his motions, discovery will come out today. Every motion needs to be particularized.
Okay, meaning the things he filed were basically placeholders.
That's what they are.
Okay. Mr. Willis is here as well. Mr. Rhodes is his lawyer. Can you grab Deputy Gordon? He should just be in his office. Hey, can I see you for a quick second?
Yeah.
You have a busy morning.
Yeah,
The gentleman standing up with the green vest is Mr. Willis. Mr. Rhodes, Mr. Willis has an active probation warrant. I just printed it out, so you can get a copy of it in a second, but he's going to need to go with Deputy Gordon. We can work through the consequences of that. It's a case out of Judge Ingram's courtroom, but that doesn't mean we can't resolve it here in connection with this case if that's in the end what you and Mr. Hiles choose to do. None of this will happen this morning, but there's just that additional moving part for Mr. Willis. Judge Ingram signed the warrant in March, and I don't think, is it based on the conduct that you've indicted?
It wouldn't surprise me. I really don't know, Judge. I'll look into it. Good news is it would be assigned to me and Judge Ingram anyways. So it's something I can. You
will be able to look at both because you're
I'll be the decision maker on all ends.
On the state side.
On the state side.
Okay.
Exactly.
Right. The two allegations are that Mr. Willis on January 19th of this year possessed marijuana and a gun, and he was a convicted felon when he did it. And then the second is a technical violation that he didn't prove that he'd enrolled in a family violence intervention program. And then the third one just recycles the first one. So the alleged offense conduct is January 19th of this year. I don't know if that's what your indictment is about.
I don't think it'll, I'll try and get this wrapped up expeditiously.
Okay. All right. Mr. Rhodes, I don't know who will handle Mr. Willis's situation in front of Judge Ingram, but again, I'm happy to consolidate. Several of us work smoothly that way. And so one, it may be that you say, oh, I want to do the revocation in front of Judge Ingram, and we'll resolve, if you're doing them together, we'll resolve this case in front of her. But we can flip it around as well. If this is a resolvable case, I'm not saying it is, but if it is, we can certainly roll the revocation into how we handle this case. Okay? Does that make sense? Okay. I think they are related, Mr. Hiles, because the arrest date for this case is the arrest date listed on the warrant. So I think it's the same offense conduct, which means under our policy, the revocation will come to me because I've got the open indicted case.
So you want me to, so when I file the state's petition, I should file it addressed to your court?
Yes. Yeah, if it's predicated on Judge Ingram's case is a 23 SC, aggravated assault, other things, that will be here based on our bench policy so that Mr. Rhodes and his client are just in one place and not two to handle all this. This is particularly interrelated because the main basis for the revocation would be the case you brought. All right, Mr. Rhodes, things went a little differently than you might have expected. Don't want to discourage you from coming back to 8D. Warrants are warrants. Any questions about what's going on?
Yes.
Yep, I didn't realize, I didn't look at the case number. I didn't realize that Mr. Willis was a co-defendant of Mr. Brown. Mr. Brown's entry on my calendar lists all these counts, gang case. And so I just flipped over and said, what's the next case? Mr. Willis is a co-defendant in that gang case. And so not Ms. Davis, Mr. Hiles. His case, and he also will be handling the revocation. So cross out Davis, get a case with her some other time. Right, Hiles, it sounds like he's got discovery at the ready. So he'll get you that evidence.com link or whatever it is. I'll get a scheduling order in place that will set the deadlines, discovery first, then your motions deadline. And we'll move this consistent with the scheduling order, but if you're moving faster, that's fine. If we reach a point where there's something you want to get into court, just reach out to Ms. Nelson and we'll figure out how quickly we can do that. Okay? Other questions?
Anything I can tell Mr. Willis as to when his revocation hearing might be?
So I would talk to Mr. Hiles first because we could do the revocation hearing real soon, but if Mr. Hiles is going to say, I don't know how much time is left on the, yeah.
Yes, 3 years, 4 months.
Okay, so we could do it soon, in a matter of just a few weeks, if the state's going to need to bring witnesses. If it's something negotiated, we could do it even sooner. But you're going to want to understand from Mr. Hiles what he's likely to recommend. And if he's going to recommend revoke the balance because of this new case, then you and Mr. Willis want to talk about, well, shouldn't we just resolve the new case as well? Because it may be that Mr. Hiles's recommendation on the new case is the same as the revocation. So stop number one would be communicate with Mr. Hiles. And if he is way up in the stratosphere with recommendations and you want to get this revocation going, we can do it. That's fine. Okay. You're welcome. Sorry about the minefield. But you still should do the waiver form. Good. All right.
Sure, let's see, good when you're done with it.
Jonathan Terry.
He's on the Zoom, Judge.
There he is.
How you doing? Good morning, sir.
Good morning, Mr. Terry. How are you?
I'm doing great.
Great. Ms. Wood, is this your case?
It's mine, Judge. I'll be filing a waiver this morning.
All right. Let me just add you to the spotlight right there. There you go. Mr. Terry, can you see the young lady in the pink jacket?
Absolutely.
Okay. That's your lawyer. That's Ms. Wood. She is going to file a waiver of arraignment in your case, meaning she's entering a plea of not guilty at this time. And then she'll get discovery, meet with you, talk about the discovery, what are the strengths and weaknesses in the state's case, and we'll go forward from there. Okay?
Yes, sir.
Let me ask you a couple questions once I pull up your case. Ms. Davis, will this be your case?
Good morning, Judge. That one's mine.
Ms. Dilligard, yours. Okay. Just cause?
It's a DV ag assault.
Okay. Mr. Davis, I got a couple addresses for you. Are you at Welcome All Road or Bixler Circle? Mr. Terry?
I'm in Union City, 4483 Union City.
Okay. So what I'm going to do is have you get the address to Ms. Wood, and she can do a change of address form for you, because we've got a Welcome All Road address in Atlanta and then Bixler Circle in Decatur. Neither one of those is Union City.
Mm-hmm.
Was it your birthday recently?
No, my birthday is coming up. My little boy's birthday is just passed. Oh, no, his birthday tomorrow, to be honest.
All right, well, someone has a happy birthday balloon floating behind your head. So, wondering whose birthday it was. Happy birthday to whomever. Let's check out your bond. Given that this is a Dilligard case, there may be important conditions. Order for bond. Here it is. All right, so your bond from January of this year, you're wearing an ankle monitor?
Yes, sir.
Okay, and you are supposed to stay away from a Ms. Reed. Are you doing that?
Yes, sir.
Okay. Do you and Ms. Reed have any children together?
Yes, sir.
How is it that are you spending time with that kid or those kids, or for right now, you're just not seeing them?
No, I just see my son. I just go through her mother for right now.
Okay, good. Keep doing it that way, but talk with Ms. Wood, your lawyer, if we need to restructure that. It's important that you stay compliant with the bond conditions, and we will see how all that plays out. But you're staying away from Ms. Reed. You go through her mother to see your son, and we need to get your current address. Does he have a way to reach you, Ms. Wood?
Oh, yes.
Okay, all right. Will you please text Ms. Wood your Union City address so we can get that change of address form?
Yes, sir. I can do it right now.
Good. Ms. Dilligard? She just left. Ms.
Slipped out very briefly.
Okay. Anything from the state on this one?
No, Your Honor, nothing further.
Okay. All right. So, Mr. Terry, once you sent that address to Ms. Wood, you are good to go.
All right.
Oh, you're back.
Yeah.
And-
We left.
Okay, Mr. who?
Rhodes.
Oh, Mr. Rhodes. Okay, do you have anything you want to add about Mr. Terry's case?
Yeah, I'll get with Lacey, so I think this will be one we can resolve.
Okay, Mr. Terry is seeing his son, but going through grandma to work that out and is not, he says he's not contacting Ms. Reed. So that's where we are. Yeah, I saw that, but it was filed before. There was a speedy trial demand, but that was filed. Yeah, it was before it was indicted, so that's not a, you and Mr. Terry can talk, Ms. Wood, but I don't want him thinking or the state thinking that that clock is ticking. It was more, I think he couldn't make bond initially, and that was what was triggering it. Let me see, who was filing all these things? Someone filed Mr. Terry was. All right, Mr. Terry, you got a lawyer now, so don't file anything else on your own. If you want something in the books, you have Ms. Wood do that, okay?
Yes, sir.
All right. If there's nothing else, Mr. Terry is free to go. Thank you. And happy birthday to all the people and all those flowers.
All right, thank you.
All right, see you. Deputy Gordon, were you able to sort out Mr. Sinkfield's situation? He is free to go. All right, Mr. Sinkfield, there was a warrant that showed up in the system out of DeKalb, but it's not a valid warrant. So I don't know if you had business in DeKalb. It's probation in DeKalb. All right, well, it's not a warrant we can hold you on. So you should go now. And Ms. Taylor's free to go, but you too may want to reach out to DeKalb to say, wait, is everything all right in DeKalb? Okay. Ms. Taylor, we'll get you that scheduling order. Ms. Davis will get you discovery again, and we'll move the case along. Thank you for being here. Okay.
I'll get up and leave the court in a minute.
You take your time, Mr. Sinkfield. It's a comfy place. Let's see what's next. Samuel Lashappelle.
Good morning, Your Honor. Manny Aurora and Mr. Lashappelle here.
Hey, Mr. Aurora, let me get you on the screen. There you are. There's your client. So today is arraignment day. What are we doing?
We waiving arraignment. We filed the discovery motion back on April 24th.
Okay. Did you file a waiver or do you need to file a waiver?
I'm filing it now. I didn't realize I needed to do that, but I'm having it drafted right now by my paralegal.
Okay. It does not need to be particularly sophisticated, just waive arraignment. And it sounds like you've already opted into discovery. Once we get your waiver, I'll do a scheduling order that'll set a deadline for Ms. Winfrey, who is the prosecutor on the case, to get discovery to you, Mr. Aurora. You and Mr. Lashappelle can look at it, file whatever motions, and we will move the case along. Mr. Lashappelle, your bond order is very old. Just want to make sure there aren't any conditions that may now be sort of antiquated. Are you still living with your parents?
Yes, Your Honor.
Okay, that was a bond requirement as of February 2023. If for some reason that needs to change, talk with Mr. Aurora, and he and Ms. Winfrey and I can talk about amending that. But it sounds like for the last 2 years, you've done what the bond order said. Mr. Aurora, anything else on behalf of Mr. Lashappelle?
No, Your Honor.
Okay. Who's playing Ms. Winfrey today?
I can play Miss Winfrey
Okay.
today.
Anything from the state?
Nothing further. I know she's currently in trial, so that's
Okay.
All
right. Then Mr. Aurora, we'll look for the waiver and get things rolling from there. Mr. Lashappelle, any questions for me?
No, sir.
Okay. Well, thank you. Mr. Aurora, you've got the next individual as well. Is he seated to your other side? He's on the screen there. Mr. Winslow. All right. Exit stage left, Lashappelle. And here is Winslow. Hello, Mr. Winslow.
Hello, Your Honor.
Is this your new line of cases, Mr. Aurora?
It just happens that they've been pending for about 3 years.
They
We also
have.
filed discovery on this on April 24th. They all just got indicted together.
Okay,
And I'll file the waiver as well, just change the names and. file the
great.
anticipated.
Same thing, as with Mr. Lashappelle. Once that waiver is in, we'll do the scheduling order and, Ms. Winfrey, will get discovery to you. Let me take a look at Mr. Winslow's bond. I'm sure it's equally old. Okay. So Mr. Winslow, you are supposed to stay away from a particular school. You've been doing that?
Yes, Your Honor.
Okay. Was that a place where you were employed?
Yes, Your Honor.
Okay. That's the main specialized condition. Oh, there were others. There was a different bond order, April 28th. Here it is. Oh, okay. All right. Mr. Aurora, anything else on behalf of Mr. Winslow?
No, Your Honor.
Okay. Ms. Dilligard, same stand-in for Ms. Winfrey. She's in trial. State's ready to get discovery over?
As far as I know, Judge, yes.
Okay. All right. Then we are done with both those cases. Mr. Winslow, any questions for me?
No, thank you, Your Honor.
All right. Then you are free to go. Thank you, Mr. Aurora. If you don't get discovery soon, be sure to reach out so these cases don't get even older. Okay?
Certainly, and when you do your scheduling order, if you could give us some time, I'll need a computer expert because it's going to deal with computers on both cases.
Okay.
So it'll take a while to go through all the data that we're probably going to get.
Sounds good.
Right. Thank you.
Bye-bye.
Bye.
All right. Mr. McGriff, your lawyer had not provided the necessary paperwork for this evaluation to happen, so you didn't miss anything. This was a Schnipper issue. He got the information this morning to the folks who lined this up. The goal is to get you together with the doctor sometime in the next couple weeks, okay? So you should look for, I don't know if you'll get a call or something from your lawyer or if it would be from Emory, that's where the doctors come from. But we're gonna try to line up a date and time for that to happen, okay? Any questions about anything? All right, you're free to go. Oh, not so fast.
Before, I just wanted to, I just looked back at my notes on the April 10th hearing. I know that Mr. Schnipper had stand-in counsel appear for him and Mr. McGriff and his mother appeared by Zoom. They indicated that they were on their way to get the forensic interview at that time. Then at the next setting, I think David Schnipper appeared and said that that was not correct. They had a misunderstanding. And he basically indicated that he did not think that Dexter McGriff would qualify to get a competency evaluation and they were going to have to self-pay. And he indicated that at the next hearing, which is this one, that they anticipated that the forensic interview would be done.
Okay, I don't doubt your notes at all. We've been working with Mr. Schnipper and his schedule and his 180-day leave letter. And I'm managing that. But Our litigation manager who lines these evaluations up, both for in custody and out of custody individuals, is on it. And she is going to get this set up. We will have a different issue if she says, here's the date and time, and Mr. McGriff doesn't show up. But it sounds like Emory is prepared to do the evaluation. We just need to make it happen. So hopefully Mr. Schnipper will follow through with Mr. McGriff and we'll go from there. Okay. Mr. McGriff, it sounds like you're all set. No other questions? All right, Mom, any questions? No. Okay, you're free to go.
May I be excused, Your Honor?
Yes, ma'am. Winfred Sherman.
He's my judge. He should be in custody.
Oh, as in here.
Yes.
Do we have a Winfred Sherman?
Yes.
Okay. Who's got two cases? All right. All right. We got through that. How are you doing about getting someone?
Oh, no.
Okay, we're gonna do a sentencing for Mr. Willock, who's right here. And then we're ready for whatever you can make happen. Great. Mr. Willock, if you'll come on up to the podium, please. Good morning, how are you? That's all right. We did non-needing a record things first.
Yeah, they did, because they did agree to the fact.
All right, let me call up your file. Money, you ever to the Atlanta probation office? They provide the address at all. Yeah. Okay, Ms. Davis, are you handling this or is Ms. Dilligard?
Judge, I'll be handling that.
Great, okay. Well, let's get on the record. This is 24 SC 002-174-02, State versus Owen Willock. Mr. Willock is here in court. Can I have your last name again?
Dorfman,
Dorfman. Can you spell that for the record?
Dorfman.
With Ms. Dorfman, who is a colleague of Mr. Pines. And we, in March of this year, Mr. Willock, did the guilty plea part. I think you were appearing virtually from school. Yes, sir. And you entered your plea. I accepted your plea. Really what's left is the imposition of a sentence. And we deferred that, not because of any hiccups, but you were in school and you actually need to be here physically in person to connect with probation and get signed up, and for that probation to begin the process of getting your supervision transferred to what state?
Kansas.
Kansas. Okay. All right. And what I'm remembering, and then I will hear from Ms. Davis, she can say, whoop, nope, that's not where we were. Oh, that's right. You were studying aerospace at University of Kansas. That what had been negotiated was a first offender sentence of 5 years probation, completing the Alive at 25 program, 50 hours of community service, be either a full-time student, aerospace, or be employed. A letter to Mr. Muhammad, who is the person you hit. And I'm not remembering what the T stands for, but TVIP. And it's something about don't be a bad driver, but that program as well. Ms. Dorfman, is that consistent with the notes you have?
Yes, Your Honor. And we do have the written apology letter and the Alive at 25 here today.
As in a certificate of completion?
Correct.
Okay, great. Ms. Davis, is that consistent with the notes that someone gave you from what we did in March?
Yes, Judge, there's one clarifying point. It's my understanding that there was a 3-year good day.
Okay,
That's correct.
got it. Now, Mr. Willock, am I pronouncing your last name correctly?
Willock, Your Honor.
Willock, Mr. Willock. A bid date is a behavioral incentive date. It means if you have done all the things that were part of the conditions of your probation and equally importantly, stayed out of trouble, then after 3 years, probation can petition me to close the case out. It's an incentive to head in the right direction. There's no penalty if at the end of 3 years you haven't done your community service or you had some issues between now and then. You still have 5 years probation, but it's a way to have things end early. Ms. Davis, I'll start with you. I don't know if there is, I don't recall if there was victim impact information that had been provided before. I probably would have said, let's defer it till now when we're actually talking about sentencing. And even if there's not, if you just have any information as to how Mr. Muhammad is doing, that's helpful for me to know.
I can step in. Judge, at the time of the plea, we hadn't made victim contact at that time. We have since then, I've talked with him and he knows of the resolution, and it's my understanding that he's doing well.
Okay, and he's not opposed to this outcome?
No, Judge.
Okay. I crossed out restitution when we had our plea hearing. And so I'm assuming that's still the case, that Mr. Muhammad is not out funds that Mr. Willock ought to be responsible for.
None that I'm aware of, Judge.
Okay, got it. All right. Ms. Davis, anything else you want to add from the state side?
Nothing further, Judge.
Okay, thank you. Ms. Dorfman?
And Your Honor, we would respectfully request the court go along with the negotiated agreement in this case. And I know Mr. Pines had prepared an order sealing the case on the front end due to the first offender status. And I believe Ms. Dilligard was aware of that as well.
Okay.
So, and then again, I have the certificate of the live of 25 and the apology to Mr. Muhammad. Who should I give those to?
So the certificate you'll probably want to give to Ms. Simpson, or it may be she says, give it to the person that Mr. Willock's going to go meet down. He's going to go to the probation office from here, but you all can talk when we're done. Ms. Davis, the letter of apology to Mr. Muhammad, is that something your office would get to him? Or I think that's cleaner because you've had contact rather than having DCS have to figure out how to track Mr. Muhammad down.
Yes, Judge, we would utilize our victim's advocate to provide that letter, that apology letter.
Great. Okay, so that's taken care of. Mr. Willock, anything that you want to share with me, with the state, before I impose sentence in your case?
No, Your Honor. I believe I'm supposed to, I have the TVIP scheduled for, I think, the 25th or 26th later this month.
Okay.
So that'll be completed later this month as well. And I plan on completing the community service this summer.
Okay, and you'll be in Georgia for the summer, or are you? Okay, so we've got time for the transfer of supervision to work. That's good. When you're here in Georgia, what county will you be living in?
Fulton.
Fulton? Okay. That's where you'll be initially supervised then. It will be Fulton County probation, and then it can be transferred to Kansas. What do you think TVIP stands for? I don't know. You're not in trouble for not knowing. I've only been told like 10 times, but
I think it's traffic.
we usually do FVIP, and I know what that stands for, but the V doesn't make sense.
I think it's victim impact panel, but
Yes, traffic violators impact panel.
Oh, is that a big municipal court thing too? No, you're running about, okay.
Yeah. Like recently.
Got it. Traffic violators impact panel. It sounds like it's just a one-time thing?
Yes, Your Honor.
Okay. All right. Well, good. Well, I'm glad you've got that lined up, and it makes a bunch of sense to knock out the community service this summer. What else do you have going on this summer?
I'm taking classes. I'm also trying to learn a new coding language. So I'm also keeping busy.
Okay.
Academically.
All right. Online classes or Georgia State or Kennesaw State?
Online classes. Okay.
Will you get credit at University of Kansas?
Yes, Your Honor.
Okay. And remind me what year you will be in when you go back.
I will be my junior year.
Okay. All right. Any questions about anything?
No, Your Honor.
Well, Mr. Willock, I already found you guilty, and found that there's a factual basis. What we're left with, well, I guess I should ask again, are you taking any medication these days?
I do take medication, yes.
Okay. And would you take it in the morning or the evening?
Morning.
Did you take it this morning?
Yes, sir.
Does that medication in any way interfere with your ability to understand what we're talking about right now?
No, Your Honor.
Same as before. Good. All right. Mr. Willock, I will sentence you as did we talk about the benefits and risks of first offender already?
Did Mr. Pines go over that with you?
Mr. Pines went over.
Okay, well, I need to do that on the record. You're asking to be sentenced as a first offender, which means this is not a conviction. So if you're applying to graduate school or for work, and one of the questions on the application is, have you ever been convicted of a felony? The answer is no. Even though serious injury by vehicle is a felony, this as a first offender disposition is not a conviction. You will be on probation and it will look and feel just like you have a conviction, but you don't. If you successfully complete probation, when your case is closed out, then you're in a position to say, I remain someone with no conviction. That's the benefit of first offender, and you certainly qualify for it. The risk is that if probation doesn't go well and you pick up new charges, not only would you have new charges, but the state could come before me and ask that I revoke your first offender status, which would mean I would resentence you as a convicted felon, and I'd have the full range of each of these offenses to sentence you. You'd get credit for the time you've been on probation, but you've already pled guilty to these things, and I could resentence you in theory up to the maximum. I don't know that I would, but I'll tell you, if something like this happens again in the next few years, here in Fulton or wherever, that new offense would be a basis, even if it happened in Kansas, would be a basis to revoke the first offender and resentence you. And I share that with you not to sound ominous, but just to make sure you're thinking carefully about whether you want to be a first offender. If you think that this kind of situation is in your rearview mirror and you aren't going to do something like this again, first offender makes a bunch of sense. But if the junior year at Kansas is often kind of crazy and whatnot, maybe you don't want to do first offender. Have you had a chance to think about it and discuss it with your various lawyers?
I do not plan on regressing and committing any more crimes.
All right, then it says to me you'd like to be sentenced as a first offender. I will do that. Count 2 is a misdemeanor. It's misdemeanor reckless driving?
Yes, Your Honor.
Okay, all right. I'm going to sentence you, Mr. Willock, on count 1 to 5 years. Counts 2 and 3 will both be 12 months. They will all run concurrently with each other, and they will all be probated. Special conditions of probation are: number 1, complete the Alive at 25 program. Sounds like you've done that. Present that certificate to probation today. Check that box. Complete 50 hours of community service. While you are on probation, you need to be either enrolled in school or working at least 20 hours a week. You need to write a letter of, I'm actually not going to include that because you've done it. You don't need to show probation that. You gave it to the state. You do need to complete the Traffic Violators Impact Panel, TVIP. And if P means program instead, you got to do that instead. TVIP. I will set a behavioral incentive date of June 11 of 2028. That's 3 years from now. If you've done everything you need to do and you have kept probation happy and haven't been hard to find, then I'm very open to probation saying, let's close out Mr. Willock's case, and we would do that. Any questions about anything?
No, Your Honor.
Okay. I know that this situation happened a long time ago. It's almost already 3 years in your rearview mirror. And so it may seem peculiar that here we are fussing now. Sometimes justice moves slowly. For Mr. Muhammad, is moving slowly for you, but it's necessary to get this kind of closure. I'm optimistic that those kind of days are behind you, and that school and family and a new profession will keep you heading in the right direction. We'll see what happens. Ms. Davis, anything else from the state?
No, Your Honor.
Ms. Dorfman?
I was just going to present the order prepared by Mr. Pines as far as the front end first offender sealing.
Okay, and there's no objection from the state about the sealing?
No, Your Honor.
No? Okay, you can give that to me. You're welcome. If there is nothing else, then Mr. Willock, when you're done, talk with Ms. Simpson real briefly, and she's going to give you reporting instructions, which are go this morning to Memorial Drive. It's just a few blocks from here, and connect with the person who's here for another hour and a half or so. Okay? Thank you.
Thank you, Your Honor.
How we doing?
So, he brings two rooms to the door, and then the third room, she's gonna do three, and he do that.
Okay,
So, do that.
okay. I thought you said the colonel was going to be here.
She's in another court.
Okay. Are there that many courts in session today, or it's just vacation time? Both?
Another court and.
Do they have a jury yet?
Uh,
That's like day 6 of jury selection.
Put a note on the door for like moving courtrooms or something.
Yeah.
What's the charge?
It is a human trafficking case. And it's apparently real hard to get a jury.
They're not gonna have a jury until maybe Thursday or Friday.
Is this what Ms. Winfrey is doing? Okay, I saw Mr. Francis when I was heading out. I know he's one of the lawyers in the mix. She's gonna be out of pocket for a while.
2 years.
Yeah, and that's gonna be interesting, because Mr. Francis, I think, was first out for the Emerson calendar. He can't do that, so that'll have to go, which means our case moves up. All right.
Owen is trying to straighten the jury right now in front of Judge Dennis.
Huh, all right.
Y'all are busy today.
Yeah.
Mr. Francis is also on the Rogers Horn Speedy. That should be first out on your.
Oh, dog, he's gonna have to waive his speed. If he can't be here, I had to do a little research on that, but he can't cause an acquittal because he's unavailable. That's not working out so far?
I think his will resolve. The other one, because I was trying to catch Mr. Rhodes about Horn, who also has a speedy.
Oh, right, he got on that case. I knew that name was, okay. He's the one who backed out of the immunity at the last second. Okay,
That one, I'm not sure. Will resolve.
okay, and then Mender.
He's going back to juvenile court once I
Yes.
figure out how.
Oh, okay, great. I'll have to work through that. Okay. So Ms. Wood, it sounds like a couple of your clients we will bring to the door just to do the waiver of arraignment. Is that Mr. Ailero?
Yes. And Gay? Yes.
Okay.
Ailero and Gay.
Got it. You either one, just tell me which one you're doing. Ailero? Okay, the first one. McGriff.
You have to be found in this position of decision. As soon as he signs it, and I'm seeing right here.
It's probably gonna be like, I don't know, you my attorney. Like, but you know Haley.
So Mr. Burden never made it. Oop, right there. There we go. Hey, are you Mr. Ailero?
Yes,
I'm all right. Did I pronounce that correctly? All right, Mr. Ailero, I'm Judge McBurney. You have 3 cases in my courtroom. Ms. Wood is your lawyer for each of those 3 cases. And today is your arraignment day on all 3. Normally we'd bring you all the way out to the podium, but we're down 1 deputy. So sorry to keep you pressed up against the wall there. Ms. Wood has told me she's going to waive arraignment for you, which is entering a plea of not guilty to each of the 3 cases. That'll trigger an obligation on the prosecutor's part to get discovery to Ms. Wood. She'll come see you, let you know, hey, this case, the state has good evidence, bad evidence, whatever the deal is. And then you and she will talk about next steps. Oh, hey, look at that. Now we have a 2nd deputy. Excellent. We'll get you in the right position.
So waiving
Go ahead.
arraignment means you're saying not guilty. That's what that means.
Yeah, so today, all we're doing is Ms. Wood is entering that plea of not guilty in your 3 cases. I'm gonna enter what's called a scheduling order that sets some deadlines. So these move, you're stuck in jail, you want progress, these things to happen. Ms. Wood will be meeting with you to talk about whether there are any motions that she thinks she should file, like a motion to suppress. I don't know anything about your 3 cases, but if one of them involved the police saying, hey, come here, and you didn't want to come here, and they grabbed you, maybe they shouldn't have done that, and that should be suppressed. She's also going to talk to you about working the cases out. She will meet with the prosecutor, Ms. Davis, and let you know what the state thinks they might recommend. I will see you next, either because there's a motion that Ms. Wood has filed, or because we get to your final plea date, which is the last day to work things out where you've got the ability to say, no thanks, Judge, if the sentence I give you, you don't like. And obviously at the end of the road, if that's where we need to get, is trial. And we'll do a trial of one or more of your cases. You got a bunch of moving parts because it's 3 cases, and the state would decide which case they want to have go first. But we'll see how that plays out. I just said a lot. Any questions about any of that?
Yes. So, am I eligible for my first offenders, being as though I have no charges and no convictions here, no felony convictions, anything here in Georgia?
So, well, 2 things. One, you said here in Georgia. If you have a felony conviction from Texas, you're not eligible, or any state. I just
Even
picking
if I
on
never
Texas.
used my first offenders? I've never used it.
So if you have a felony conviction from anywhere in the United States, then you're not going to be eligible for first offender here in Georgia.
Okay.
That's answer 1. Okay. Answer 2, if you have no felony convictions anywhere in the US, including Puerto Rico, then there are ways in which you can consolidate for sentencing all 3 cases. That's not a guarantee. I'd have to be comfortable with that because there's 3 different cases. I need to learn more about you, what's going on with the cases, et cetera. And we'd have to hear from the state. They might oppose it. They don't control it, but they might oppose it. So I don't want you to get out ahead of things. But most of all, if you know, hey, I picked up a felony in Florida or Ohio or wherever it is, then you're not eligible for first offender. Yes. They look nationwide to see if there are any felony convictions. And it may be that, hey, you use the equivalent of first offender in Tennessee. We don't get to use it again here in Georgia. Did that answer your question?
Yes.
Okay. Any other questions?
Yes, one more question. There's right now, there's like no plea agreements on the table, right?
So probably not. Ms. Dilligard, you're standing up. Are you going to handle the 3 cases?
No, Judge, but one of the cases is a domestic violence case.
Okay.
So position 4, I will handle, and then
Ms. Davis will handle the other 2.
Yes, Judge.
All right. So you got 2 prosecutors, not just 1. They will talk with Ms. Wood and say, here's what we're thinking. But it is early enough on that Ms. Wood probably, I mean, she may have an offer from them, but she may be thinking in her head, I got to look at the evidence in this case. Because gosh, that offer seems high, and it may be that one of these cases, I know I could get tossed with a motion to suppress, and one of them is shoplifting. Oh, come on. So she needs a minute to digest the discovery, to share with you her thoughts, and then she will work with both Ms. Davis and Ms. Dilligard to say, what would a universal resolution look like? No one wants to, all right, we'll plead to one and then fight over another one. It would be an all or nothing kind of thing. So she will be working on that. Ms. Wood, anything from you?
No, Your Honor, I will get those waivers filed and my entry in on all 3 cases, and I'll be out to see him once I get discovery.
Great. Ms. Dilligard and Ms. Davis, any reason to think discovery will be complicated in these cases?
No, Your Honor.
The booking numbers are all pretty recent. They're the same for 2 of the cases. Is it all, it's all recent conduct, it looks like. So we're not indicting a 2022 incident. Okay, good. That'll make it flow easier.
You are, but we'll talk about that after today, okay?
Because I'm at my 90-day mark right? And I'm eligible for a bond at my 90-day mark, correct, Judge?
If you haven't been indicted. If you have not been indicted at 90 days, you are eligible, but you're indicted now, so the 90 days doesn't trigger any opportunity for you. So Ms. Wood, when she comes out to talk to you, when she's got discovery, she'll cover the whole waterfront because you're going to want to, hey, if we're not going to work it out right away, how about bond? And she can give you her.
I haven't talked to nobody since I've been indicted back in April of last month.
Okay, well, this is the first, I don't know when the indictments came down. But what I do know is that this is the first it's been assigned to me and thus to Ms. Wood. So this is her first opportunity to meet you. She will now start moving these forward. I'm going to enter a scheduling order that sets some deadlines that aren't particularly flexible, that will require the state to get moving. And Ms. Wood will come talk to you to cover next steps. Okay?
Yes, sir.
All right. Thank you.
Thank you, Judge.
Thank you.
Now that we have two deputies, we can bring, is Mr. Gay, who you wanted to have come out?
Yes, Judge.
Okay, so he has, what's his case that's under judicial hold?
It's 24 SC 004574.
That was changed.
No.
Wait, why did we get an older case?
See, that's why I'm thinking that they were thinking that the Gay and George were the same person, but I don't know.
Okay, that may go back.
Hey, Mr. Gay. How are you?
And why wouldn't this go to them?
You're on for this case.
Because it's called.
Okay. Because if they have an older one,
Hold on just a second.
we'll talk for now, but I'll put on the radar the possible transfer. Mr. Gay,
Yes, sir.
how are you?
I'm all right.
Good. I'm Judge McBurney. For now, your case is assigned to me, and I need to be clear about cases. This most recent case that we're going to talk about involves an allegation that someone named Mr. George, who a lot of people thought was actually you, mailed you drugs in the jail. That's the allegation. I don't want you to tell me it's a great allegation or it's a bad one, but that's the case that brought you here today. You have an older indicted case that's with a different judge, and that may cause this case that I just mentioned, someone supposedly sending you drugs at the jail, to be transferred to that judge.
Okay.
That's not going to slow things down. It just means different judge, so that your two cases are in front of the same judge, because this older case.
I think it's ours.
Oh, darn. All right. It is what it is. Let's see this older case. Oh, yeah, that's our case. Okay. Your older case is an aggravated assault charge from May of 2022, and it was indicted in 24, and we couldn't find you at some point, I guess. I don't know. But Ms. Wood's going to handle that as well. You are a popular guy. You also have 3 cases with Judge Richardson for which you're on probation. And so she has signed probation warrants, and we'll deal someday, not this morning, with all that stuff. So your new charge, which is Mr. George mailed drugs to the jail, your kind of medium age charge, which is an allegation that you assaulted a woman named Jessica Lamar in May of 2022. Yes, that's 3 years ago, but that's the case that was already with me, the older case. And then we'll deal with those probation revocations. Today, we're just doing the waiver of arraignment, meaning Ms. Wood is entering a plea of not guilty on your behalf in connection with both the mailing drugs to the jail and this aggravated assault case, because I don't see a waiver in that one, I think, because we didn't see you at a hearing. So she'll file the waiver of arraignment. She'll get discovery from the prosecutor, and I will see you once either there's a motion that Ms. Wood files on your behalf, or you and she have figured out a way to work out the revocations and these two cases.
Okay.
All right?
All right, thanks, sir.
I just laid a lot on you. No questions?
No question.
Okay. Ms. Davis, you would be handling the case that's on the calendar. I don't know about the aggravated assault. It's a female victim. That doesn't mean it's DV, but it will be moving along. We'll do a scheduling order for that one as well. And I guess the D team needs to figure out who's got that one. All right?
Understood.
Okay. All right. Thank you, Mr. Gay.
Bye, Mr. Gay.
So we need a warrant from Martavius.
Yes, and we'll do a bench warrant on Mario George.
Yes, another case of non-profit.
This is a Velcro thing. It's interesting how different two people can be. Mr. Ailero, lots of questions. What's this about? Mr. Gay is like, hey, that's fantastic.
I love that.
Can I get a lollipop?
Not seen anyone. Miss Taylor spent a lot of time
Yeah.
with them.
Apparently you count as no one. The number of times I've heard defendants say, I'm not seeing my lawyer. And then I hear afterwards, like, yeah, except yesterday when I went to talk to him. But that's just sometimes how it is. All right, so to recap, we'll do a bench warrant. Hey, Ms. Davis, I'm gonna go over the calendar real quickly. So I just want to make sure, since the bench warrants will flow from you. Position 7 and 8 will be bench warrants. And then everything else we've taken care of, except Winfred Sherman may be a plea. And I know you had said this afternoon, but if we've got 2 deputies now, we can do it now. It's really up to you. Do you need to talk to him?
Just briefly.
Okay. Why don't we try to knock it out this morning? And our final plea is set for 1. But I have case management committee from 12:30 to 1:30. So we're actually going to start at 1:30 this afternoon. And we have our trial meeting this afternoon also. And we don't need to wait until, I think it's on the calendar at 4. But if we finish all our other calendars and we've got everyone here, we can just roll right into that.
Yeah, not for sure. Okay. Sure. I know, great.
Yeah. All right, you want me to sign this Willock thing?
Yes, please. I was wondering why you did all the, it's unassuming with the sentences.
I kept my notes.
Oh, good.
We also have nothing to this,
She's been surprising.
Yeah, you didn't even show up yesterday. It's like, where's the team? It's like, nah.
I have stuff this afternoon.
How you being so quiet? She's on good.
You act like I'm wild every other day.
Off chain reels.
For the lead is trans.
No, not.
Let it break in for that week.
Hi.
How are you?
I'm Deidre Nelson.
Nice to meet you.
I heard many wonderful things.
I hope so.
Yeah.
Everybody doing?
I hyped you up.
Everybody's like.
Oh, well, that's
yeah,
good.
the people's chamber here. You guys are. Okay, so you can't really do anything. This is that, my sheep will go.
Oh, in case we get. So ex-boyfriend. So you said we together. Yeah, so. Friday, he stabbed her. He cut her arm, she stabbed him. He went outside. Busted her windshield to a car in the back window. She didn't feel having a good time with his car. Jesus Christ. Right. They both. And then they called the cops and then he runs in the woods and she's like, his car. And they saw the blood, so they never look at.
I need to see the body cam on this.
Yeah.
That
was just.
They end up just here?
It just him and her fighting.
No, they got that. I was.
I was trying to be positive. Trying to be positive.
Okay. It looks like Misty already said. Was it like 20? I made it up. Was it her on? Wow. Just as the bottom is still order.
I don't see that, but I have, for Willock.
Yes, is that the name?
Yeah, but if there's an electronic version, I'm happy to sign this and then you can manually do it, but.
Yeah, I'll wait till the process is on this position.
Okay.
Maybe we can take the plea. Postpone the same thing that. Yeah, so I'll just. You might be interested. But I mean, I guess it doesn't matter, it's a good trial.
You email? I didn't know that. Wow.
No, you can see that.
Oh, okay.
My printer don't work from the computer.
Oh, you got Windows 11?
No, it's not. It's the paper cuts.
Oh, I heard you complaining about that yesterday.
It won't allow me to print from Fulton County.
From my house, this is a lot.
That's a lot.
No, but I was too bad to copies. How many copies?
So I have to email everybody, print for me.
Well, should we get IT to come fix it?
He tried like 3 times. He said he was gonna, next time, he was gonna uninstall it and try to do it again. But he went on vacation. So,
Is our IT guy?
I think it's how, yeah, Jamal.
Is that a sheriff's IT person or is it?
Yeah, sure.
Oh, okay.
It's different IT.
So Superior Court has IT. So like when one of the cameras isn't working,
Is that like?
Cleveland and Aaron is the guy with the short pants. Yeah, yeah, totally call him. Yeah. There you go.
You're just waiting.
Get it, Aaron Dorsey, right?
Since it's still consider me. Yeah, maybe free.
Okay.
He's so nice to meet you.
I'll take it. He's like, yes. Get me out of here. I got so much to do. Okay.
I'm glad I
Yeah, the Perry and the Durante. God. This afternoon.
Oh, is it right? Oh, you understood.
Oh, he left?
Yeah.
Oh,
He was bouncing back and forth, so.
oh, okay. So we should
Wanna do it right back? See if I got you.
see if we can get someone. Yeah. Take a little pressure off this afternoon. Waited.
But Judge, we can, even if the state hasn't given me an offer, we can still do a plea, right?
Oh, yeah.
Yes, Judge, but we need an opportunity to make contact with both the victims. I mean, these are allegations of assault with a weapon. Basically, both folks shot. And so.
Wait, someone got shot?
Yes, Judge. I believe in both cases, and so we need to have an opportunity to speak with both separate victims.
And Judge, I get that, but he's been in custody over a year, so I don't know why the state hasn't made contact yet.
So, two things. One, I certainly can take they're consecutively numbered indictments. I certainly can take the plea, and defer sentencing. So he can hear it, give the state a very, very short fuse to reach out to the victims in the two cases. And then we would reconvene, sort of like Mr. Willock, just not as far down the road to take care of sentencing. But you'd be able to make your recommendation now so he could hear it. I just explained to Mr. Sherman that we would do sentencing in a few days. Would he be interested in doing that, or?
Possibly, Judge. He's been in custody consecutively this whole time, so that's why he's eager to
Sure.
have these cases.
Okay.
And Judge, according to our notes, one of the victims is in custody, so we would need probably a little bit more time to make contact with that individual. I believe that was the victim of the first case.
In custody as in at the county jail or in the state system?
Not sure exactly where in custody.
Just not at liberty.
Well, not sure. Yes.
Okay. All right. Well, we'll see what happens. Pardon? Yeah, I heard that before.
Worst case for Shane, using custody. And show you to the victim.
Yeah.
Doesn't seem strong at all. Wait, the little girl said he touched her butt. And the school investigating something business issue. Yeah. That's, is it never? Yeah. Yeah, we will definitely be on trial on that one. And also, I think like every time he was like trying to tell me that like he actually knows the mother. Did he tell you that? No, he didn't tell me that part. We didn't talk. Weird like story. So he thinks we have like some ulterior motive. Exactly. I wouldn't even, I left a message, but she didn't call me back, so I'll try again today. Yeah, but I'll try again, and if I don't hear anything, because we have them on, we don't have them scheduled yet, but we just need to get it resolved. I'm gonna call today, and if he doesn't call me by the end of the day, it's a woman. If she doesn't call me by the end of the day, then maybe you could try to get in touch with her. No, I do. Let me see. And they stay on because I expressed something. Yeah. It's like you have a kid. Yeah, I see that back at work. Because they'll probably get paid. The like, you know, lab, the nails. Like, yeah. So. Okay. And you just put them under the lamp and stuff. Are these fake nails? Or there's no. That one will give you just the nails and the need to paint. Oh, okay. Maybe like a kit like this. Well, just gonna say show what exactly does it call or just you just get the nails? I just got the nails because you can't cure. Is it? Yeah. Also dangerous. Yeah. I get the clear ones. Oh, so you hate it. Thank you. Okay, I don't know. Yeah, I wanted to joke because it's faster. Look your jokes. I used to just get them, but I didn't have time for that. Yeah. So yeah.
Mr. Sherman?
Sir.
Come on up to the podium, please.
Judge, I do have a question.
Okay.
Since we're early enough in the process that if he wants to withdraw the plea, if the non-negotiation does not go his way, would that just happen whenever we do the sentencing portion? Okay.
Sure. Let me explain, Mr. Sherman, what I think we're going to do today to make sure you and I are on the same page. Ms. Wood told me that you are interested in entering a plea to your two cases. You've been in jail for a long time and are understandably anxious to put this behind you and move forward. When Ms. Wood came out to tell me that she was prepared to go forward with pleas on this calendar, which is your first appearance in front of me, this is your arraignment date. Ms. Davis, who's the prosecutor on your two cases, said, of course, Mr. Sherman can enter the guilty plea, but the state is asking for a few days' time to contact the victims, to get victim impact information. Victims have a right to be notified if a case is being resolved. And so what we would do today is simply hear the basics about the case, the facts and circumstances that the state thinks were sufficient to bring these charges. I'd learn a little bit about you from Ms. Wood, and then I would decide if I'm willing to accept your guilty plea. So is there sufficient evidence, and do you understand your rights as a criminal defendant and the rights that you'd be giving up by entering a guilty plea? Then we'd stop. And we will get back together in a few days to get to the part that really matters to you, which is, well, what's the sentence going to be? And that's when Ms. Wood will advocate for whatever you and she have talked about. Maybe it's time served, maybe it's 18 months. I don't know. She'll argue on your behalf for what the two of you talked about. At that time, Ms. Davis will have been given an opportunity to communicate with the victims. Maybe she's successful, maybe she's not, but you don't have to wait forever while the state tries to track these people down. I'm going to give them a little while to do that. And if they're successful, they can engage with the victims to understand their perspective and relay that to me, because that's something I ought to consider as well. I ought to consider what Ms. Wood and you think the right outcome is, but I also ought to hear from Ms. Davis that, well, I'm making this up. This guy was shot in the knee and he can't walk well anymore. He thinks that Mr. Sherman should get 100 years. Okay, it's important for me to hear that. That doesn't mean you get 100 years. In fact, you're not eligible for 100 years. But I need to give the state, I'm required to give the state an opportunity to connect with the victims. So today is just, do I accept your plea or not? In a few days would be the sentencing part. If at that sentencing, I sentence you to anything more than what Ms. Wood asked for, you will have the ability to say, no thanks. I'm going to go back and let's go to trial and we'll move your case along that way. So you have the ability to back out, even though today we're not going to finish everything because I need to let Ms. Davis have a chance to track down the victims. When we do reconvene, I'll hear more and I'll say, all right, here's what I'm going to do. I'm going to sentence you to X. And if X is more than what Ms. Wood asked for, you and Ms. Wood can talk about it. Sometimes it's only a little bit more and the defendant says, it's better than that, then go on to trial. Sometimes X is a whole lot more and a defendant says, no, I would rather a jury hear the evidence and we'll figure out what happens there. And then my goal will be to get you in front of that jury just as soon as we can. Does that make sense, what I described?
Yes.
Understanding that, do you want to go forward with your two pleas today?
Yes.
Okay. Then in just a moment, Ms. Davis is going to put you under oath. She's going to ask you a bunch of questions about your rights as a criminal defendant. Please answer those questions truthfully and completely. And if at any point you've got questions, someone says something you don't understand, or it's not going the way Ms. Wood said it would be going, pause, ask me the question, ask Ms. Wood the question, and we'll work through it, okay? Yes?
Yes, sir.
Okay, good. Make sure when you're answering the questions, some of them may be yes or no questions, that you actually verbalize your answer as well. You're welcome to nod your head or shake your head, but Ms. Rivers, the court reporter, can only take down the words you say.
Yes.
Excellent. Ms. Davis, when you're ready.
Judge, please raise your right hand. Do you swear or affirm that the testimony that you will give in this matter currently before the court shall be the truth, the whole truth, and nothing but the truth?
Yes.
Please state your true and correct legal name.
Winfred Sherman.
Can you spell your first and last name for the court?
WINFRED SHERMAN.
Are you at this time taking or under the influence of any alcohol, drugs, or medication?
No,
Is there any medication that you normally take that you have not been given today?
no.
How old are you and how far have you gone in school?
I'm 43, 11th grade.
Where'd you go to high school?
I went to Carver and Douglas.
Are you able to read, write, and understand the English language?
Yes,
Are you a United States citizen?
yes,
Do you understand that you are charged with the following offenses? I'll take them one at a time. For indictment 25 SC 002841, you're charged with 1 count of aggravated assault, 1 count of possession of a firearm during the commission of a felony, and count 3, possession of a firearm by a convicted felon. Are you aware of that?
yes,
Are you aware of, in 25 SC 002842, that you're charged with 1 count of aggravated assault, 2nd count of possession of a firearm during the commission of a felony, and a 3rd count of possession of a firearm by a convicted felon?
yes,
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
yes,
Have you had enough time to speak with your lawyer, Ms. Wood, about the facts and circumstances known to you regarding the charges in both indictments and any potential defenses?
Sahara.
Do you need more time to discuss this case with your attorney?
No,
Are you satisfied with her services?
yes,
Ms. Wood, do you waive formal reading of the indictment and any and all defects therein for the purposes of this plea?
So waived.
Mr. Winfred, do you remember being arrested on both of these charges?
yes,
Judge, the state is unaware at this time of any outstanding warrants related to these charges. Attorney Wood, are you aware of any outstanding warrants related to these charges?
No, I'm not.
Mr. Winfred, has your attorney advised you of the minimum and maximum sentence for each charge to which you're pleading to today?
yes,
Do you understand that if your guilty plea is a blind plea, also called a non-negotiated plea, the state will recommend a sentence to the court?
yes,
Do you understand that the court can impose any sentence authorized by law, including a higher sentence than that recommended by the state, up to the maximum sentence on this charge?
yes,
Do you understand that if you enter a non-negotiated plea, you do not have the right to withdraw? Well, I'm sorry. We actually do have the right to get rid of that. Do you understand that this is a guilty plea which will be permanently recorded on your criminal history?
yes,
Are you currently on probation or parole?
no,
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction, as well as other jurisdictions, including federal courts?
yes,
Do you understand if you are not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just like a conviction at trial would? And that is true regardless of any advice by your attorney or anyone else.
yes,
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you'll be guilty of a felony which may carry a sentence from 1 to 15 years in prison?
yes,
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial?
yes,
For example, your guilty plea may affect the right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to possess or transport a firearm, or the ability to obtain employment.
yes,
Do you understand that you waive any and all defenses, including any mental health offenses, by entering a plea of guilty?
yes,
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury,
yes,
the right to remain silent and not incriminate yourself,
Yes.
The right to confront witnesses against you.
Yes.
The right to the assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at the trial of your case.
Yes.
The right to the presumption of innocence.
Yes.
The right to testify on your own behalf and to present other evidence.
Yes.
The right to subpoena witnesses and compel the production of evidence.
Yes.
The right to have the charges against you proved beyond a reasonable doubt.
Yes.
The right to appeal the convicted of these charges after a trial.
Yes.
You understand that you may have only a limited right to appeal this guilty plea conviction?
Yes.
You understand that you have only 4 years from today for a felony charge to file a habeas corpus petition challenging the voluntariness of your guilty plea?
Yes.
How do you plead to the charges on indictment 25 SC 002841 to the counts of aggravated assault, possession of a firearm during the commission of a felony, and firearm by a convicted felon?
Yes.
How do you plead in indictment 25 SC 002842 to one count of aggravated assault, possession of a firearm during the commission of a felony, and possession of a firearm by a convicted felon?
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter this guilty plea?
No.
Is it your decision to waive these rights and enter a guilty plea because you're in fact guilty?
Yes.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
Judge, at this time, we'll provide a factual basis for the pleas. We'll take the first case, 25 SC 002841. On May 20th, 2024, located at 2656 Donald Lee Halliwell Parkway. Atlanta police officers were called out to that location for a person shot call. When they arrived on the scene, they met with the victim, Mr. Darnell Green. Mr. Green stated that he went to the gas station to purchase cigarettes. He was engaged in another conversation when someone walked up to him and said, "What are y'all on?" There was a quick exchange of words and the suspect reached into his waistband, grabbed a gun. At that time, Mr. Green began to run and was shot 3 times. He did not realize he was shot until moments later. Officers were able to review the video surveillance footage from that location. They put out a suspect photo, and he was identified positively by the victim, Mr. Green. On 25 SC 002842, approximately 4 days later, at May 24, 2024, officers were called out to 2650 Donald Lee Halliwell Parkway in Atlanta, Georgia, and Fulton County.
Is that the same address?
It is a very similar address,
Okay.
Judge, very close
All right.
to each other. At that time, Fulton County Sheriff Officer Deputy Lee was flagged down by an individual, Mr. Britt. He indicated that a male was lying in the Chevron parking lot, had been shot. He began to administer aid while the individual provided a description to the deputies of the individual who shot him. They were able to locate that suspect, which would be the defendant, at a Martavius station. He did have a semi-automatic pistol on his person. It had electrical tape wrapped around the grip and handle. The officers were also able to review footage of the incident where they were able to see that Mr. Marshall, the victim, Willock Marshall, and Mr. Sherman, Winfred, were arguing in front of the store, and Mr. Sherman produced a firearm and shot Mr. Marshall several times. You could also see Mr. Marshall, the victim, running away. When they did encounter and engage Mr. Sherman, he voluntarily said that Mr. Marshall didn't know who he was messing with. The victim sustained 1 gunshot wound to the left abdomen and right calf. Also, Mr. Sherman is charged with possessing a firearm as a convicted felon. I did obtain a certified conviction for that felony. It is 06 SC 40274. He pled guilty on July 13, 2006. That was a conviction for possession of a firearm by a felon.
All right. Good morning, Ms. Jackson.
Good morning, Your Honor.
How have you been?
Good. How are you?
I'm hanging in there. Can you share criminal history information, please, on Mr. Sherman?
Yes, sir. There are 23 cycles. The last arrest was April the 12th, 2016 with the City of Atlanta Police Department for possession of marijuana less than an ounce. There was no disposition for that arrest. He does have prior felony convictions. One in 2006 for aggravated assault and possession of a firearm during commission of a felony. One in 2005 for possession of controlled substance. One in 2003 for false imprisonment and theft by taking. One in 2002 for possession of marijuana with the intent to distribute. And one in 2000 for possession of controlled substance. He does have misdemeanor convictions. One in 2010 for simple battery, family violence, and criminal trespassing. One in 2004 for giving false information to an officer and tampering with evidence. Nothing in addition.
Thank you. Ms. Wood.
Judge, do you want me to go ahead and tell you what I'm going to be asking for?
You might as well get it on the record so Mr. Sherman hears it and knows it's on the record and you've planted that poll. And then I'll let Ms. Davis wait so she's had a chance to talk to Mr. Green and Mr. Marshall and get their thoughts.
Perfect. Judge, as you know, I generally do not have clients enter pleas at arraignment to such serious charges. However, Mr. Sherman has been adamant that he was eager to resolve. And so I've told him, I don't have full discovery here. I'm very limited in what I can say about the strength of the state's case at this time, but here we are. And so that's why I was pushing to let us plead today. Judge, he's 43 years old. He's a lifelong resident of Atlanta. He's a Crawford Long baby, not a Grady baby. All of his family's here. He has 4 children, ages 15, 16, 20, and 23. He has a 10th grade education. He was working at Clark Atlanta University in the kitchen. However, he did get injured, and so he was in the process of working on getting disability benefits when these incidents happened last year. Judge, he's been in custody since the last arrest, so he's been in, I think it's 382 days. Prior to these 2 incidents that were so close in time and close in location, he had not been arrested since 2016. One of the cases he maintains would have been, there would have been an argument of self-defense. There was, of course, something else to the story that we don't quite know everything that was transpiring, Judge. I do just want to point out from the warrants, it sounds like both victims were able to get away. I didn't hear any mention of medical treatment, even though they were both shot. He's asking the court to consider a sentence of 10 serve 1, Judge.
Got it. Okay. All right. Mr. Sherman, I do find that there's a factual basis for your pleas in both cases. If the state was able to prove up what Ms. Davis just said, a jury could find you guilty of aggravated assault. It sounds like in one and maybe both cases, there are some potential defenses of self-defense or who knows, mistaken identity, but sounds like a jury would see video evidence. And in particular, if Mr. Green and Mr. Marshall were to testify, they might be able to say, that's the guy who did it. And that's not me saying that trial would go poorly for you. It's me saying a jury could convict you. And so I can accept your guilty plea. I also find that your plea is knowing and voluntary. Voluntary means no one's forcing you to enter this plea. And I know that's true here. You are saying, let's do this. And knowing means you've understood all the things we discussed. Do you have any questions about anything? Okay. Then I will accept your guilty plea in both cases. I will defer sentencing to give the state a little opportunity to track down, if they are able, both Mr. Green and Mr. Marshall, and then we'll reconvene. And as I told you before, if in the end the sentence that I impose is more severe than 10 years to serve 1 year, you'll have the ability to withdraw your plea. It won't be automatic, meaning I'll ask you and Ms. Wood to talk about it, because maybe I'll say 10 years to serve 1 year and 1 day. Anyway, you know what? I'll do that. In fact, you've already done a year and a day. That would be dumb for me to change it. Basically, Ms. Wood has asked for a time-served sentence. But if I sentence you to more than that, you'll have the opportunity to consider it and then either reject it, you're not going to hurt my feelings, then we just move towards trial, or accept it and say, I would have liked less, but I don't really want to go to trial. I don't think that'll end so well for me. And then we'd handle it that way. So I will get you brought back here once we're in a position to do the rest of the sentencing. I'm gonna ask it now. Ms. Wood, do you authorize someone on my staff to sign the 2 indictments on your behalf?
Yes, Judge.
Ms. Davis, can we sign for you?
Yes, Judge, but I did put off. Do you want me to sign it?
Oh, wow, look at that. We'll talk about that afterwards. Mr. Sherman, if we go forward with the sentencing, is it okay if we electronically sign your name to the indictments indicating your 2 guilty pleas?
Yes.
Okay, all right. Then we're gonna pause now. We've gotten as far as we can. And then we'll reconvene in a few days to talk about the state's recommendation, and then assuming that recommendation is not 10 to serve 1, what I'm gonna do about the sentence, okay? Thank you, everyone.
Thank you, Judge.
All right, we are done with this morning's calendar. Ms. Jackson, we are not going to start up until 1:30, not at 1. We have one calendar that's published for 1, but I have a meeting that's going to go 12:30 to 1:30. So we're keeping this Zoom?
Yes.
Okay, so the Zoom will stay up. You're welcome to stay on it, but we won't reactivate until 1:30.
Thank you, Judge. I'll see you then.
You bet. All right, I will mute that. Max Sharp,
Good afternoon.
good afternoon. What brings you here?
I have a case.
Okay, great.
You're older.
Well, maybe we'll get there.
All right.
I noticed a bunch of the cases were Ms. Cabrera's, but I think she's in that trial. What we're gonna do with that, we'll see. Okay. We have, I'm sorry, we're starting late. A final plea calendar. Today is the last day you can resolve your case with a plea and have the ability to withdraw your plea if you don't like the sentence you get. You can always enter a plea later on, you just won't have that ability to withdraw your plea. Oh, look, there's your case, Mr. Sharp. All right. So all the cases today will end up on the July 10th trial calendar. If they are not resolved today, 1 month from now, you'll be back and we'll be figuring out who's going to trial and all that kind of stuff. And it turns out that's a 2-week trial calendar in July. So position 1 is Quabina Palmer. Not online. Okay. Did you hear from Ms. Cabrera? She is. I think she's in the Judge Lethbridge. Okay. Well, I don't think did she say excuse all my clients or she just said I'm in trial? Okay. All right. Is Troy Britton here? That's your client, Ms. Rios.
Yes, Your Honor.
Maybe they're traveling together.
Possibly.
When did you last speak to Troy Britton?
Yesterday, she thought court was yesterday and said she was at the courthouse.
Oh, I'm sorry. Okay, you were not.
No, neither was she supposed to be. So I don't know. We're just gonna.
You guys-
I'll reach out to her again.
Yeah, you told her she would need to come back. It wasn't like, hey, you showed up and we weren't ready, so case dismissed.
Did not say that.
Okay. Well, let's hold then. Maybe if they're traveling together, they'll come in together. How about Kwame Harris? Mr. Harris is here.
We are ready with a non-negotiated plea.
All right, Ms. Davis, will you be handling that?
Yes, Judge, I will.
All right, we will do that this afternoon. Darshawn Taylor. Hello, Mr. Taylor. Your lawyer is Ms. Cabrera? That was a question. You don't think so? 5447. Ms. Rios, do you have Mr. Favors?
Yes, he's on the Zoom.
Okay, I see that. So I do think Ms. Cabrera is your lawyer, Mr. Taylor. She is in trial right now, which is tough timing because about half the cases on this calendar are her cases. Yep, okay. All right. What we're going to do, Mr. Taylor, for your case is move it to the trial calendar, but I will preserve your final plea rights. Did you get something in the mail telling you to be? How'd you know to be here? Okay, so you're still living at the same place? All right, I'm gonna let you go. You'll need to be back here on July 10th, but you're gonna get something in the mail telling you to be here on July 10th. Before then, Ms. Cabrera is gonna be talking to you about your case anyway. And it may be that you and she asked to come in before July 10th to work the case out, okay? Any questions? All right, I'll see you around. So that gets us to Mr. Favors, who is on virtually. What are we doing today with his case?
Referral to adult diversion.
Adult diversion,
Yeah.
meaning the DA's diversion.
Yes.
Got it.
And I will be referring him to diversion.
Let's get Mr. Favors. Hey, Mr. Favors, can you turn your camera on, please? Yikes, I thought you might be wearing a shirt.
Oh no, I just woke up.
Okay, well, sorry to wake you up at 1:53 in the afternoon. You ready to talk a little bit about your case?
Yes, sir.
Okay, let's get Ms. Rios on the screen as well. There she is. All right. So it sounds like, Mr. Favors, you are going to do the diversion program. Is that your understanding?
Yes, sir.
Okay. Ms. Davis, has Mr. Favors been accepted into it? Or sometimes what I hear from the DA's office is like, well, we're hoping, I'm not sure, I haven't heard.
Correct. We're in the active process of referring his case. Once it is accepted or if it is accepted, we will present an order to the court or the conditions.
Okay. Any reason to think it would not be accepted?
Not at this time, Judge.
Okay. And have you actually, I learned once how this works. Either you have to send an email or fill out a form. Has that happened yet? Or you're just optimistic that you will submit whatever you have to submit?
I have filled out a form, however, you do have to submit an updated GCIC, which I requested.
Okay. So there's a form, you've done that, you'll get the updated GCIC to the diversion people, they'll chew on it and then let you know, yes, Mr. Favors is in, or no, he's not.
Correct, Judge, and usually it takes about a week or so. Not too long.
Okay.
Fairly soon.
All right. And then you'll let Ms. Rios know and Ms. Nelson. And if it's that he's in, then I think there's an order I sign or something.
Correct.
Okay. All right. Ms. Rios, do you have good contact information for Mr. Favors? Yes. All right. Mr. Favors, if you are accepted into the diversion program, there's some requirements you have to meet, stay out of trouble for a while, that kind of stuff. And then if you do all those things in the time allowed for those things, the state dismisses your charges. Is that your understanding of how it works?
Yes, sir.
Okay. Well, we'll see if you're accepted. I think you likely will be, given what these charges are, but I don't control that. If you are accepted, Ms. Rios will let you know, and then you'll just need to make sure you take care of all the requirements of the program. And we'll go from there. Any questions?
No.
Okay. Ms. Rios, anything else on behalf of Mr. Favors? Okay. You can go back to bed.
All right, thank y'all.
You bet. All right. So what's the program? Is there a formal name for the program? Just adult diversion?
Yeah, it's called adult diversion.
All right, so if I put a little tickler in to say I should be hearing something within a week, that's enough time?
I would say typically, I would say most of the time, I do get an answer back within the week. Occasionally, it takes a little bit longer and it just depends on somebody out.
Okay. All right. Taishay or Shia Bernard? Taishay, good afternoon. Thank you for being here. Ms. Bernard, I think your lawyer is Ms. Cabrera, but I'm confused on this one because Michael Ross, is Michael Ross here? In custody. He also has Ms. Cabrera listed and you guys are co-defendants. So do you remember who your lawyer is, Ms. Bernard? No? Okay. It's been that kind of case. Well, let me look. Is there also a 5, 8, 6, 7? There's another defendant, Amari Martin. Hey, Mr. Martin.
We are ready on a non-negotiated plea.
You represent Mr. Martin?
Yes.
Okay, got it. Rios. So we need to figure out who represents whom. Okay. Yeah, I got Miss Cabrera on both. That's not gonna work. Okay. Miss Bernard, I appreciate you being here. Did you get something in the mail telling you to be here? Oh, it's like last time you were here, someone gave you the specific day you needed to be here? Okay, well, let me make sure we've got a good address for you, because you should also get something in the mail. And really, you should be hearing from your lawyer, but your situation is a little funky in this case. I have an address of Tartan Court in Union City. That's you? Okay, well, you should be getting, is there an apartment number or it's just a street number? 4639? Okay, well, you should be getting things in the mail. We need to figure out with Miss Cabrera if she's going to represent you or Mr. Ross. She's currently listed as the lawyer for both of you, and that's not really how it should work. But she's in trial, so I'm going to excuse you now. You should get something in the mail telling you to be back here on July 10th, 1 month exactly from today, but you're also hearing it from me that that's when we're calling the trial calendar that your case is on. Before then, Ms. Cabrera will talk with you about the case, unless it turns out she's going to be the lawyer for Mr. Ross. And I don't know how they work that out. Okay? So I will see you at the latest on July 10th, right back here in this courtroom, okay? Any questions? Thank you for being here. Jillian Nelson?
Good afternoon, Your Honor. Mita Ololoyi on behalf of Mr. Nelson. How are you, Judge?
I'm well. How are you?
I'm doing well, Your Honor. Your Honor, Mr. Nelson is currently in the Department of Corrections, and it appears that he is currently serving a 20-12. I'm not sure how the state would want to go about it. They did provide me some discovery. I haven't gotten an offer yet. But given that Mr. Nelson is in the Department of Corrections, I've not had any conversation with him in regards to this case, or I don't think I've had any conversation with him, period, Judge. I would ask if we can, I'm not sure if moving it to another final plea would, at this point, move things. I know I won't be ready to try, given I've not had any conversations with him. So I would kind of defer to the court on how they would like to proceed in regards to next court day. If we just leave it on the trial calendar, I'm not sure what the court would prefer.
Well, I know that Department of Corrections would prefer that Mr. Nelson stay where he is rather than be shuttled around the state, brought back here for a trial calendar, et cetera. You mentioned that you have some discovery. Do you feel like you don't have all the discovery?
Yes, Your Honor, because in the report, it did indicate that there was surveillance footage. I have not received the surveillance footage. They also did reply indicating that there's no body footage, but the report does say that there was surveillance footage, so I don't have that. So I would be hoping the state would be able to provide that, but I do have paper discovery. I believe the only thing that's missing is that CCTV footage, Your Honor.
Got it. And this is something that happened, it looks like at the jail. So
Correct.
It would be whatever cameras they've got there.
Correct, Your Honor.
Okay. Okay, got it. So if we got you that last bit of discovery, you'd have everything you need. Have you tried to work through GDC to have a call or a conference with Mr. Nelson?
That I have not, Your Honor.
Okay. I can help with that in that we, the courts, have liaisons with GDC that set that kind of stuff up.
That'd be great, Judge.
Okay. I'll make a note of that. Ms. Davis, what do you know about video footage of the riot in the penal institution?
Well, I did take a look at the certificate of discovery. It does seem like there was only documents that were shared with the attorney. I did peruse evidence.com. I do not see any video footage, but I will connect with my investigator to see if there is additional surveillance footage that we can obtain from the sheriff.
Okay. But you don't, I don't know how the DA's filing system works, but are you able to tell whether that's something that's in your possession or that's by looking at evidence.com? If you had a video, that's where it would be.
Correct. So
Got it.
it's not currently in our possession at this time.
Got it. Okay. So we've got a two-step process. I'd like to keep this on the calendar for July 10th, Mr. Ololoye. This seems like a resolvable matter given Mr. Nelson's sentence that he's serving right now. But I don't want to impose that on anyone. But if we can get you that discovery and get you connected with Mr. Nelson, he may well prefer resolving it with a Zoom session like this, and then just continuing on with the larger sentence that he already received. So I'm gonna keep this on the July trial calendar, but make a note, one, that I need to connect you, Mr. Ololoye, with the GDC folks, and then two, to bug Ms. Davis in a little while to see, we'll just get an update from her as to what's going on with the surveillance footage.
That's fine, Your Honor.
Okay. I don't think so. All right, Mr. Ololoye, anything else on behalf of Mr. Nelson?
Nothing else on behalf of Mr. Nelson, Your Honor.
Ms. Davis, anything on behalf of the state?
No, Your Honor.
All right, thank you for being here, Mr. Ololoye. You're good to go.
Thank you, Your Honor. You all have a great day.
Alberto Trujillo Garcia. It is. I just had to call his name. Ms. Davis, Mr. Trujillo's lawyer has told us that he has gone to Mexico. Not the lawyer, but the client. And he's not expecting him back. I excused the lawyer from today. And he said, look, I know you're going to issue a bench warrant, which I will, or I'll request you to prepare the necessary paperwork. But his lawyer identified a few weeks ago that he had learned from the family, or maybe from Mr. Trujillo himself, that he had self-deported. So we can avoid a riot in Atlanta. Number 11, Justin Elder. There's Mr. Elder, there's Mr. Sharp. Final plea today. What are we doing, Mr. Sharp?
I would appreciate the opportunity to pre-try the case with the state. I had the opportunity before you took the bench, and I got sidetracked. I talked to Mr. about it, but.
Okay, he can distract people that way. I hope you got something of value from the conversation.
Absolutely.
It's like some new glasses. Yes, when I'm done calling the calendar, we may be able to do a plea while you're talking with the prosecutor or who knows what, but pre-trial it is. So Mr. Elder, sit tight. Your lawyer's gonna do some arm twisting and see what he can do. Claudine Hardison.
He's my judge. I think he's on Zoom.
Yes. All right. What are we doing today with Mr. Hardison?
Judge, I think it may make sense if we leave it on for July the tenth. Steve and I are working now on like a virtual PTI situation.
Not adult diversion through the wait a week to get accepted program?
Correct.
All right.
And so I just need a little bit more time to flesh that out, but I think it can be taken care of.
Okay, Mr. Hardison, can you turn your camera on, please?
Hey, I'm here.
Hey, you're here. Excellent. All right. Were you able to hear what Ms. Wood was saying?
Yes, ma'am. Sir.
Okay. So she's going to continue to work with Ms. Davis, the prosecutor, to see if there is a pretrial intervention type disposition for you where you'd have a couple requirements you need to knock out. And if you do that within the allotted time, then the state would agree to make the case go away. So we'll keep your case on the July trial calendar. That is not me saying I look forward to trying your case. I'm sure it would be a wonderful case to try. But Ms. Wood and Ms. Davis just need a little more time to see if they can agree on what the components of your diversion sentence is the wrong term, what the terms of your diversion would look like, because it's not a sentence. So I'm gonna give them a little more time. Ideally, they'll work that out well before July 10th, and you will not need to come back to court. If for some reason they can't, then you need to understand you need to be here, not on Zoom, in court on July 10th for the call of the trial calendar, okay?
Yes, sir.
Any questions about any of that?
No, sir.
Ms. Wood, anything else?
No, Judge. Mr. Hardison, I will send you an email after court today, okay?
Okay. Thank you.
All right. Ms. Davis, anything else?
Nothing better, Judge.
All right. You're good to go, Mr. Hardison.
All right. Have a good one.
He might have just woken up also.
Yes.
At least he had a shirt on. He had the comforter all around him. It's very, very low key. He's a different type of sleeper than the other guy. Mr. Gould? Tyreek or Tyrek Gould?
Judge, I expect him here, so I'm gonna step out
Okay.
after the call and give him a call.
So you're hopeful he will be here, and you're hopeful, nope, it's Ms. Rios is hopeful Ms. Britton will be here. Let me call, we got two more positions, and then we can figure out what we're gonna do with all these cases. Demetris Davis should be in custody.
It's a final plea hearing. Ms. Gerber is gonna stand in, Judge, so whenever we're ready.
All right,
Because I think that might be Mr. Abadi's one.
it is, so jumping all the way from
Yes.
preliminary hearings to murder cases.
Yes, sir.
I like it. All right, we'll do that in 1 sec. Let me just figure out, is Larion Williams here? He's in custody also.
And that'll be a plea today, Judge.
A plea. All right. Davis. All right. Then why don't we can we bring, you have just you? Okay, let's do Mr. Davis.
Quite strange to see a larger than life version of myself out
Yeah, we'll tell you the witness. When you're the witness, it's right there. That's right, Mr. Davis will take up part of the screen in just a moment.
He is taller than me, so.
Mr. Davis, come on up to the podium, please.
Hey, I'm gonna change my mind. We'll take the plea.
Okay. Your Honor, he'd like to discuss the potential of a plea more in depth. Could we
Got
have
it.
a moment?
You have 100% you can. Mr. Davis, let me tell you the significance of today versus tomorrow and onwards in connection with your case. Today is the last day that you could enter a plea in your case and have the ability to back out of that plea if the sentence I impose is longer or harsher than what your lawyer asked for. So just making up numbers, your lawyer and the state would have to agree to reduce some charges here. Your charges are pretty messy, but I'm just letting you know. Let's say they agree to reduce this and that so that 10 years to serve is a realistic legal sentence. If Ms. Gerber were to say, Judge, we're recommending 10 years to serve, the state says we think it should be 15, whatever they're advocating for. If I were to sentence you to more than whatever your lawyer asked for, you'd have the ability to take a break, talk with your lawyer and say, you know what, I'd rather just go to trial. You actually back out of the plea like it never happened. Today, we can do that. After today, if you enter a plea, whatever sentence you get is what you get. Just like if you go to trial. If you go to trial and you're found guilty, you don't get to back out of the trial. You face the consequences of having been found guilty. So today, if you do pursue a plea, you will be able to withdraw it if the sentence I impose is not what you were looking for. Does that make sense?
Yes, sir.
Okay. Before you take a break, Mr. Abate, have there been offers to Mr. Davis that are something less than life plus a whole bunch of years? No. Oh, okay. So you should still talk because you can always plead to the indictment and the state can recommend one thing and your lawyer can recommend something different. But I don't want to leave you thinking, hey, maybe today is a day where the state's going to say, how about time served or something like that. It doesn't sound like that's on the table. I'm going to have you come back out in a minute. I want to make sure your lawyer has a chance to talk with the prosecutor to understand what the state's going to recommend. And again, I know I've been talking a lot at you. Some of the charges you face, like murder, unless the state is going to agree to reduce it, and they have the exclusive ability to do that. I can't tell them reduce the charge. Unless they reduce murder, the penalty for murder is either life or life without parole. And so if they're not interested in doing some, we call it charge bargaining, then there's not a whole lot of space between what your lawyer might ask for and what the state might ask for. But we're going to talk again. I just want to make sure Ms. Gerber has a chance to talk to the prosecutor, and then she'll talk with you, and then we'll bring you back out here.
Okay. Yes,
Okay?
sir. Yes,
All
sir.
right.
Thank you, Judge.
You're
I'll
welcome.
come back and talk with you, all right?
So I'm going to do a final call for Quabina Palmer. Oh, right. Mr. Martin, Ms. Rios, that's a non-negotiated plea? Is that okay? All right, you even sent an email on that. Thank you for sending those. Elder is under discussion. Gould, was Mr. Gould not here, is here?
I'm here now. I'm sorry, Judge.
Oh, he's on.
He's here, Judge.
You did it.
My
He's
wife,
here. He's like banging around in his. All right. There's Mr. Gould.
You can see me?
I do. I can see a little. Yep. I can now see the top of your head. You're good. Okay. Can you hear us, Mr. Gould?
Yes, I can hear y'all, but I can't see y'all. I only can see me.
Okay? Well, you don't see a bright pink jacket?
No, I don't see the courtroom. I only see my camera.
I can hear y'all though.
All right, well, another shirt optional presentation. So Mr. Gould, as long as you can hear us, that's the important part. You still there?
Yes, sir.
Excellent. Ms. Wood, what are we doing with Mr. Gould?
Judge, because I was expecting him in person today, I was planning to convey the offer and discuss everything. I just sent him the offer via text, so I don't know if he would like to digest that and think about it.
Okay.
But that's where we are right now.
That's where we are. So you and he need to talk.
Yes.
Okay.
More than we already have.
Okay, so Mr. Gould, Ms. Wood needs to talk with you a bit about the state's recommendation and where we are. Do you have a good phone number for him?
I do. I need you to answer, Mr. Good.
Yes.
So Ms. Wood's gonna call you. Do you have your normal phone or you have like a special phone today?
No, this is my mobile phone.
Okay, what are the last four digits?
The time when she was calling, I was at work. You know, I work at the airport, so when I'm out on the floor and stuff, I can't have my phone out and then be on silence and stuff.
Got it. Okay, well, I'm glad you're working and keeping us going at the airport. Ms. Wood's gonna call you in just a few minutes, so make sure you pick up when she calls, okay?
All right, I'm waiting. I'm at home today with my newborn baby, so I'm waiting on her call.
How old is your newborn baby?
She 2 months now.
All right, what's her name?
Maylani.
Maylane. Well, congratulations.
Moon Gould, yeah.
Okay, good. All right. Well, Ms. Wood will give you a call and then we'll get you back on the Zoom and we'll talk a little bit more, okay?
All righty. Thank you.
You bet.
The fuck? You can open it now.
We'll mute him. There we go. So it looks like no one's bothering Ms. Davis right now. Ms. Rios, do you and Ms. Davis have a plea we could do?
Yeah, we've already talked, we're ready to go.
Right, I know you guys were. I just know we were sort of giving lawyers a chance to interact, but no one was bending Ms. Davis's ear. So let's name one of your pleas. Who do we have?
First, let's do just for the full name here.
Mr. Harris, come on up, please.
Proof of your child.
Slide. Got my name.
Judge, you mind if I hand you proof of his business?
I don't mind. Go ahead. Let me know when you're ready, Ms. Davis.
Tall.
All right, this is 24 SC 002485, State versus Quamaine Harris. Mr. Harris, Ms. Rios tells me you're ready to enter a plea in your case. Is that right?
Yes, sir.
Okay, Ms. Davis will put you under oath in just a moment and then ask you a bunch of questions about your rights as a criminal defendant. Make sure you answer all of her questions truthfully and completely. And also let me know if you have any questions of your own. If something comes up you don't understand or is confusing you, I need you to let me know. Will you do that?
Yes, sir.
Okay, Ms. Davis.
Please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before the court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
You can put your hand down. Please state your true and correct legal name.
Quamaine Cadiz Harris.
Can you spell your first and middle name?
Quaimane. And my middle name is Kidez.
Are you taking or under the influence of any alcohol, drugs, or medication at this time?
No, ma'am.
Is there any medication that you normally take that has not been given to you today?
No, ma'am. I don't take medicine.
How old are you and how far have you gone in school?
I'm 31 years old and I completed high school.
Where'd you go to high school?
I graduated from a Christian academy program. It's in Georgia. I got put it up in my phone because it's been a minute since I've been in there.
You don't remember the name of it?
No, I can pull it up.
No, that's okay. Were you at that school all 4 years or were you at?
No, it was like because I had dropped out of high school. The program, you just take the test and stuff, and if you pass it, you can go and take another test for your
GED kind of thing?
Yeah.
Okay. Were you ever in a more traditional high school?
But traditional high school, I was at Frank McLaren High School at College Park.
In College Park?
Yes.
Okay.
Are you able to read, write, understand the English language? Are you a United States citizen?
Yes, ma'am.
Do you understand that you're charged with the following offense in indictment 24 SC 002485, 26 counts of entering an automobile?
How many counts?
26.
Yes, ma'am.
Do you understand that you have the right to either plead guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, ma'am.
Have you had enough time to speak with your lawyer, Ms. Rios?
Yes, ma'am.
Have you discussed all the facts and circumstances known to you regarding the charges of this indictment, including any potential defenses?
Yes, ma'am.
Do you need more time to discuss this case with your attorney?
No, ma'am.
Are you satisfied with her services?
Yes.
Ms. Rios, do you waive the formal reading of the indictment and any and all defects therein for the purposes of this plea?
Yes.
Mr. Harris, do you remember having been arrested on these charges?
Yes, ma'am.
Judge, we are not aware of any outstanding warrants related to these charges. Ms. Rios, are you aware of any outstanding warrants?
No.
Mr. Harris, has your attorney advised you of the minimum and maximum sentence for each charge to which you're pleading to today?
Yes, ma'am.
Do you understand that if your guilty plea is a blind plea, also called a non-negotiated plea, the state may still recommend a sentence to the court?
Yes, ma'am.
Do you understand that the court can impose any sentence authorized by law, including a higher sentence than recommended by the state, up to the maximum sentence on each charge?
Yes, ma'am.
Did you understand that this guilty plea will permanently be recorded on your criminal history?
Yes, ma'am.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as other jurisdictions, including federal courts?
Yes, ma'am.
Do you understand that if you're not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just like a conviction at trial would? And that is true regardless of any advice by your attorney or anybody else.
Yes, ma'am.
You understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm or use a firearm in a crime, you'll be guilty of a felony, which may carry a sentence from 1 to 15 years.
Yes, ma'am.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following trial?
Yes, ma'am.
For example, your guilty plea may affect the right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes, ma'am.
Do you understand that you waive any and all defenses, including mental health defenses, by entering a guilty plea?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury,
Yes, ma'am.
the right to remain silent and not incriminate yourself,
Yes, ma'am.
the right to confront witnesses against you,
Yes, ma'am.
the right to the assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case,
Yes, ma'am.
the right to the presumption of innocence,
Yes, ma'am.
the right to testify on your own behalf and to present other evidence,
Yes, ma'am.
the right to subpoena witnesses and compel the production of evidence,
Yes, ma'am.
the right to have the charges against you proved beyond a reasonable doubt,
Yes, ma'am.
the right to appeal a conviction of these charges after a trial.
Yes, ma'am.
Do you understand that you may have only a limited right to appeal this guilty plea conviction?
Yes, ma'am.
Do you understand that you have only 4 years from today for a felony charge to file a habeas corpus petition challenging the voluntariness of your plea?
Yes, ma'am.
How do you plead to indictment 24 SC 002485 for the 26 counts of entering an automobile?
Guilty under Alpha.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No, ma'am.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes, ma'am.
Is this plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
Judge, we believe at trial, the facts would bear out that on August 27, 2022, at about 8:15 p.m., near the location of 600 Martin Street in Atlanta, Georgia, and Fulton County, that the individual before us was observed on surveillance camera footage, driving a blue envoy truck to a location where two individuals exited the vehicle and proceeded to break into 26 cars. And then after they were finished breaking into the vehicle, they did get and return back to the defendant's vehicle. Officers were able to review FUSA's camera footage, which is kind of surveillance footage for the city of Atlanta, track the description of the vehicle to a tag, ping the tag to some of the tag card readers, and attribute that vehicle being driven by the defendant.
Because the vehicle was registered to him or it ended up at his address, or what connects?
The vehicle is registered to him. There was also, it's my understanding, some cell phone tower pinging information that they were able to obtain as well. So I think it was the combination of the surveillance camera footage, the tag reader, and the cell phone.
Got it. So you're not necessarily saying that Mr. Harris was one of the two guys who got out of the truck? Could be, but you're saying at a minimum, the evidence would show his truck, his cell phone, all connect through data, et cetera, with what happened.
Correct.
Okay. What about restitution? That's a whole lot of cars.
There were a whole lot of victims as well. We've made contact, I want to say it was the 6 or 7 of the victims. Not all the victims were able to be contacted. That was going to be our ask, a part of it, to have a restitution hearing at a later date and time to make sure that we got those specifics for the cost, whether it was a deductible or outright cost paid by the victims.
Okay. Got it. Thank you. Good afternoon, Ms. Jackson. Thanks for rejoining us.
Yes, sir.
Do you have any criminal history information for Mr. Harris?
There are 14 cycles. The last arrest was February 25th, 2020 with the City of Atlanta Police Department for 2 counts of possession of marijuana with the intent to distribute. There was no disposition for that arrest. He does have prior felony convictions. It's one in 2015 for possession of a firearm by a convicted felon, one in 2014 for aggravated assault, and bus or rail vehicle hijacking and one in 2013 out of DeKalb County for burglary. He does have misdemeanor convictions, one in 2019 for a non-fingerprintable offense, and another one in 2019 out of Douglas County for possession of marijuana and criminal trespassing. And there was another one in 2019 for possession of marijuana less than an ounce and theft by receiving stolen property. Nothing in addition, Your Honor.
Thank you so much. Ms. Rios.
Yes, Your Honor. Mr. Harris is 31 years old. He's born and raised in Georgia. He has one daughter who's 12 years old that he does share custody with the mother and provides financial support. He's the owner of the Trinity Towing Company, which those are the documents that I provided. In regards to this case, he was doing it under Alford because he's been cooperative. He went down to the police station when they asked him to go down. He's spoken to the officer. The only thing connecting it is his vehicle. They're not alleging that he actually broke into the car as his accomplice, but he understands that at trial, you'd never know what could happen. And rather than risk being convicted, to have some type of say in what the outcome is in the case. So we're asking for 5 years probation so he can continue to care for his daughter.
Okay. Ms. Davis, I didn't write it down, so I don't think you said it, but I may have missed it. What was the state's recommendation in the case?
It was 5 serving 1 year.
Okay, any conditions to the probation?
Yes, Judge, we wanted the defendant to participate in an anti-theft prevention course, perform community service hours in the amount of 60 community service hours, and we wanted to reserve the right for a course of restitution hearing.
Got it. Okay. All right, and what you're recommending, Ms. Rios, is a straight 5 years probation?
Yes, sir.
Okay. Mr. Harris, tell me a little bit about Trinity and Towing. It's a towing company. What's the Trinity part?
Trinity, that's actually my daughter's name, and I just put her on top for.
Got it. Trinity and Towing, but it's not like a church and towing. It's a towing business.
Yes, it's towing business.
Okay, and you've had that, it looks like, since December?
Yes.
Okay. Do you have that fancy red truck like in the card, or that's just?
I actually have a white tow truck, but they're just the logo we just use.
Okay. And how long have you been, were you doing it before you started the company, or basically you've been a tow guy for the last 6 months or so?
Well, I actually just started driving my own tow truck myself as being the owner of it. Through my mother in the back. The tow truck is actually her tow truck that I came up with. You know what I'm saying?
Mm-hmm.
And that's what I've been doing ever since.
Okay. And tell me, how does that go? Are you a Monday through Friday tow guy, or it's someone dials that phone number? It could be 3 a.m. and you're out there.
I work every day except for Sundays.
Okay. And is it busy every day, or you're just available every day?
I mean, as of right now, due to the fact that I'm like upcoming one, you know what I'm saying? I just put all my stuff online and everything. They just call and then I just go. And I pay for leads as well. And
what does that mean?
It's basically another company that actually get calls for tolls, and I pay them in advance. And then when someone calls, if it's in my area, whatnot, they'll call me.
Got it.
I get to charge however I want to charge because I paid them up front.
Okay. All right. Any questions about anything we've discussed?
No, sir.
You understand an offered plea is basically when a defendant says, I don't agree with everything the state says, but I also don't want to go to trial because trial could be messy.
Yes, sir.
Okay. It sounds like it was your envoy that got mixed up in this. Your story might be, yeah, but I was somewhere else. Maybe you have an alibi, or I just dropped these guys off. I didn't know what they were going to do. And you don't need to answer any of that. But you are still saying basically that I, Mr. Harris, am going to be convicted of these counts. You understand that?
Yes, sir.
Okay. All right. Well, Mr. Harris, I find there's a factual basis for your plea, and that your plea is knowing and voluntary. That means that you've understood what we talked about. That's the knowing part. And voluntary means that no one's forcing you to enter this plea. Do you agree with that?
Yes, sir.
Okay. I'm sentencing you pursuant to the Probation Options Management Act, which means just that while you're on probation, which you will be for a while, if you have a minor violation, you and probation will address that. But if it's more serious, you get arrested for something, that comes back to me. Ms. Rios, can someone in my office sign the indictment for you?
Yes, Your Honor.
Ms. Davis?
Yes, Judge.
And I'm sure you have a copy with you, but we actually go digital here. It's easier for Ms. Nelson. Mr. Harris, is it okay if someone puts an electronic signature for you indicating your offered plea in connection with this case?
Yes, sir.
All right, we'll do that. So, Mr. Harris, this is a whole lot of cars. I wasn't there. It was a long time ago. Hard for me to believe you had no idea what was going on. But mostly my focus is that, gosh, it was almost 3 years ago. And since then, there haven't been any issues, which is a great sign. So even if you were a little bit in the mix with what was going on with these cars, you seem to have been heading in a different direction. Seem to be focused on your daughter and working, and that's all good stuff. Consequently, what I'm going to do is sentence you as to each count to 5 years. That will be probated, but a special condition of your probation is that you will serve 10 weekends, and there'll be consecutive weekends. They won't start this weekend, will start the following weekend, 10 weekends in jail. So you will turn yourself in by 5 o'clock on Friday, and then you'll get out by 5 o'clock on Sunday.
Okay.
10 weekends in a row, starting next weekend. Don't miss any weekends, because if you do, that'll be a violation of your probation, and that'll lead to more than 10 weekends in jail.
Okay.
But I also understand that life happens. If you figure out Trinity's not well, you got to be with her. I don't mean she's got the sniffles, but like I'm taking her to the emergency room and you absolutely positively can't make it by 5 on Friday, you want to call your probation officer and say, I can't do it. And you're going to need to document it. You can't just say, hey, Trinity's sick, and it turns out you went to the Braves game. But if there is an emergency that prevents you from going, you need to deal with the emergency. And we just put that weekend at the back end. It'll still be 10. It just means we'll end a weekend later.
Okay.
But if you have an unexcused absence, you just blow a weekend off. I promise you, when we have the revocation hearing, it won't be weekends. It'll be a while that you're out of commission. And that just messes with your business and being with your daughter, et cetera. So do your best to make these weekends. Special condition number 2 is that you complete an anti-theft course. Probation will help you find that class. You take it, you'll complete 60 hours of community service. That's your sentence for now. I'm leaving open this question of restitution. That's to the state. If they gather information, evidence, then we'd have a hearing. Your lawyer would have a chance to push back and say, how do you attribute that to Mr. Harris? Or, I get it, he's pled guilty, he's on the hook for this, but you need to look at his financial resources. He is a tow truck driver. He's not a venture capitalist. And so $1 million in restitution is too much, and it won't be $1 million. But we'd have a discussion about what is a reasonable amount, assuming it's documented. But that'll be up to the state whether they get us to reconvene on that. I think I covered everything. Any other conditions or anything else from the state, Ms. Davis?
No, Your Honor.
Ms. Rios?
No, Your Honor. So he turns himself in next Friday, which is June 20th?
Correct, June 20th. And then it's every weekend for 9 weekends after that, including the one I just mentioned. So a total of 10. That's it. Do you have any questions about any of that, Mr. Harris?
No, sir.
Okay. What county do you live in?
What?
All right. When we're done talking, and we're almost done, I'm gonna have you meet with Ms. Simpson. She is with probation. She will not be your probation officer, but she's going to give you reporting instructions. You'll report the very first time to the main office, which is about 2 blocks from here.
When I leave here?
No, not today. She's gonna give you instructions as in you have to report on this day or 48 hours. I don't know what the answer is gonna be, but Ms. Simpson can give you all that information.
Okay.
And then you'll need to show up on that date at that time. And you'll learn who your officer is gonna be and you'll be off and running. Okay?
Yes, sir.
Anything else, Ms. Rios?
No, Your Honor, thank you.
All right, I'm gonna give you this paperwork back. It looks like it's important paperwork. I keep this part just in case.
Yeah.
All right. I want a red truck though, not some ratty white truck.
I paint.
It's all right.
I paint. Thank you.
All right. Thank you, Ms. Rios. Mr. Sharp, do we have an update or have you not had an opportunity to do the arm twisting?
I have not twisted any arms yet.
Okay. Well, why don't you get with, do you need to talk with, is it Ms. Davis you need to talk to? Okay.
It won't take long.
That's all right. I can turn to, where did the, Ms. Gerber go? Is she talking to?
I think you might have another plea, maybe.
Okay, but I can't imagine Mr. Davis is a plea. If the state's not reducing charges, his sentences can be 500 years.
Maybe I'm confused. Never mind.
Okay, I'm just trying to, if we can get folks moving on their way, we'll do that.
Position 1 and 2 showed up.
Oh, Palmer, where's Palmer? Hey, all right. I will cross out bench warrant. So your lawyer is Ms. Cabrera. She is in trial right now. So we cannot have the hearing we were gonna have today talking about how are we resolving your cases. And in looking at your cases, they look pretty resolvable to me. But you need your lawyer here for that discussion, and she is in a trial. So what I'm gonna do is move your 2 cases to the trial calendar. That's 1 month from today, July 10th, right here. Did you get something in the mail about being here today? Good, it's good that you showed up anyway, but you also know about July 10th. Good, that's at 9 in the morning, it's not at 2 in the afternoon. Ms. Cabrera is gonna get in touch with you before then. And if you guys work something out, we'd love to do it before July 10th, because July 10th is gonna be 1 million people in court. But that's the latest you'll wanna be here is July 10th. I'm preserving your final plea rights, because we couldn't have your final plea hearing today. And we'll just have that discussion on July 10th. If Ms. Cabrera doesn't give you a call before then saying, no, let's come into court on a different day. Okay? Any questions about anything? All right, you're good to go. About Troy Britton. Oh, you're associated with Troy. Is she the one I gave that bond to and it was all this sad stuff and she was in jail?
Maybe.
Oh, Ms. Britton's in the hospital right now? Okay, why don't you just chat with Mr. Palmer real quickly to get information about Ms. Britton so we can handle this one the right way. Ms. Gerber.
Yes, sir.
Do we have an update on Mr. Davis?
If I could,
Talk with Mr. Abate?
yes, I think we're moving in that direction.
Okay,
I think there are just a couple more conversations happening, but it was a productive conversation.
good. Are you staying on the case or this was your cameo today and Mr. Davis?
I'm more excited than
I think given these charges, it would be a whole lot more exciting than some of what you see. Do we need to get Mr. Abate back in here?
I was gonna speak to him and then speak to Mr. Davis's mom, and then we'll be ready to go. Chad.
Okay, all right. We got 5 lawyers working on this.
Whole team.
All right.
No.
It takes a village sometimes.
Troy Griffin, she went to the emergency room because she has polyps in her nose. And when she wasn't able to breathe, and so, because I was surprised she wasn't here, because I did speak to her yesterday.
Okay, because she had been here yesterday.
Yes.
Okay. All right. I don't want to hear more about the condition, but I guess if she provides a doctor's note, then since she is co-defendant with Mr. Palmer on one, and that's going to the trial calendar, but preserving final plea rights, I guess we could do that. Although if you've worked stuff out.
I think that's good to just put it on the trial calendar, reserve final plea rights.
Okay. But she's got all these FTAs, so you're gonna need to get a doctor's note from her.
As soon as I get in touch with her, I'll have to.
Okay. Sure. I can't believe there's already a warrant for Jeff Von Gill. That was like 2 days. He just fled.
He didn't show up in Ohio.
I saw. He's off driving his truck somewhere else.
And he popped up in another state and was like, "Yeah, I can't make it. I'm in Oklahoma." And they was like, "Yeah, we still haven't
That's
seen
not,
you yet."
yeah.
So yeah, she wouldn't have. We're not happy.
Good.
So I spoke to my chiefs about the situation that you asked about yesterday. So she said, if you don't want to sign the warrant for the cases, as long as they're technical violations, then all I would do is just that to you for you to sign. And then you would sign it and send it back, and then we will be able to close the case out.
Okay. If it's technical violations, like we can't find him, he's not reporting kind of thing, not he picked up new charges. Okay.
But I mean, even if it's not technical, if you, to your discretion, because she says to your discretion.
Right.
If it's something that you think that it's not necessarily to have a revocation hearing.
Right. If there are only 3 months left, or there could be a year left, but he'd been on probation for 18 years
Yeah,
kind
so
of thing.
then what I would do is I would go ahead and send you the warrant, and then you can send it back saying, I'm gonna sign this, I'd rather just close out the case.
Okay.
I would then say, okay.
Got it.
I'll submit a non-compliant.
So I just send it back to you saying, for the following reasons, I'd prefer to close out the case than sign a warrant.
Exactly, and it'll be
Easy.
simple.
Okay, cool. Thank you.
No problem. Specific cases we don't have.
No, because one guy, you said he was in state custody, meaning, gosh, something had gone haywire with that one. His charges were serious enough, and when I look back at his case, he got a nice deal, and it was any violations returned to me, so I signed that one too. Even though it's like 6 months left, he can be in custody for those, so you bet. But going forward, now I know what to do. Mr. Shark.
Yes, Your Honor. I'm here for Mr. Elder, who's in the back. We are very close to resolution. I think the state just needs to I've made a request to the state. State's offering probation. I'm just asking for less probation. And I think the state would like to check with the victim to see, and also they need to get me a restitution amount. I was wondering if we could come back on I heard that you have a calendar on Tuesday. Could we come back on Tuesday to hopefully resolve this case one way or another?
17.
I want to say yes. I'm not authorized to add to calendars. Only Ms. Nelson has the authority to do that. But because it's a walk-in, I would say yes. You're not asking for anything to be published. It's just like, hey, we'll be back on Tuesday. Let me just do one thing. Marie Hamilton. Eesh.
No way, Shark. No.
There she is.
See, I should have said yes before. Yes, we'll do that. So, Mr. Elder, I know you've been here for a while today, but it sounds like folks are close to resolving this. And even if you're a little ways apart, it can be a non-negotiated plea. But we'll see you here Tuesday morning. The calendar starts at 9, so be here by 9, and I'll call the calendar, but we'll tee this up as a ready. Can you be here Tuesday morning?
I can. I may. I can. I'm going to make it work. I'm supposed to be somewhere else at 10, and I'll just.
Well, we could just say I'll call the calendar, like literally call the calendar, and then we do this first. Where is somewhere else?
City Court of Roswell.
Okay. Option 2, if Mr. Elder agrees to it, is that you could appear virtually, so that when you get off, you're actually already in Roswell.
What I'm going to suggest, Your Honor, if I could, I'm going to try to. I think that it's a very important case in Roswell, but I also think it's something that I can possibly work out over the phone. So I would like to. I have a feeling that if I get on the phone and talk to the prosecutor over there, I can work it out and free myself up for 9 o'clock, and I'll let Miss Nelson know.
All right. I was going to say plan C would be you guys get here at 10:30. We'll be doing other stuff. If you parachute in at 10:30, you're at the back of the line, and that's just a little more waiting than if you're at 9. You were already on a calendar before this, and so it's sort of what we would do once I called our regular calendar.
If I could just. I'm going to be here on Tuesday.
Okay.
One way or another. If
You'll let Ms. Nelson know. Importantly, let Mr. Elder know also. Yes. Not that you are a bad communicator, but sometimes the attorney's like, hey, be here at 9. And then you like, hey, I'm not going to be here till 11. And I'm stuck trying to keep your client comfy while you're dealing with Roswell and then coming here. So whatever you settle on, Nelson and Elder, both let them know. Davis will be here regardless. Okay.
All right. Thank you.
You bet. Mr. Elder, I will see you next Tuesday morning at some time. Mr. Shart's going to tell you when you need to be here, okay? All right. Ms. Nelson, Ms. Simpson needs you.
Did you say maybe
Awesome. Yeah, it's probably better than mine. You don't think so?
Mine was. Mine was the first page is dark. That's especially my category. That's how the officer sent it to me.
If that'll make it better.
Sure.
Send you mine and then yours is probably 5 pages mine.
So if unless the officer can provide you with a better copy, then I'll just go with that. Everyone will have trouble reading.
You guys ready for another plea?
Yeah, Mr. Martin, I was waiting for his dad to get back. I guess he's starting, his dad will come in.
If he's not comfortable starting without his dad, we can wait for his dad. It's up to your client. Okay. Is he far away?
Oh, no, he's
Okay. All right, let's do it.
Hey.
All right, this is
Amari Martin.
got it. Great. Okay. Mr. Martin, you ready?
Yes, sir.
Okay, well, let's get on the record. 24 SC 005867, State versus Amari Martin. Mr. Martin, Ms. Rios says you're ready to enter a plea. Is that correct?
Yes, sir. I want to hear the pleas first.
So two things, you get to hear a lot of things. The way this is going to flow is that you're going to be asked a bunch of questions about your rights, et cetera. And ultimately, you're going to be entering a plea of guilty or an offered plea, however you and Ms. Rios have structured it. And I'll accept that plea. And then we'll get to sentencing. If the sentence that I give you is more severe than what Ms. Rios asks for, you'll have a chance to withdraw your plea if you want to. So just as an example, if Ms. Rios says, Judge, I think you should sentence Mr. Martin to 6 months in jail. And I say, I think it should be 9 months. 9 months is more severe than 6. And so you two could talk about it. You could decide, yeah, but I'll do 9. That's close enough. Or you could say, no, I was willing to do 6, but not any more than that. And so if you want to say, no, thank you to this whole process, you can do that, but it won't be till the very end. When I tell you what the sentence is going to be. Before then, you'll be saying, yes, I plead guilty, I did these things, or I was part of it, et cetera. The end will do the sentence, and then you'll be given a chance to have the final word of, I'm good with the sentence, I'll stick with it, or no, I'd rather go to trial. Okay? All right, Ms. Davis is going to put you under oath, ask you the questions she needs to. I'll have some questions, and we'll go from there.
Yes, sir.
Ms. Davis, when you're ready.
Please raise your right hand. Do you swear or affirm the testimony that you shall give in this matter before the court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
You can put your name down. Please state your true, correct, and legal name.
Amari Martin.
Can you spell your first and middle name for the court?
Amari. Middle name Maurice.
Are you at this time taking or under the influence of any alcohol, drugs, or medication?
No, ma'am.
Is there any medication that you normally take that you have not taken today?
No, ma'am.
How old are you and how far have you gone in school?
18 years old and 11th grade, going to 12.
Where are you going to high school?
I'm finna go back to Tri-Cities High School.
Okay, when you say go back, did you have to take some time off from high school? Or you just finished your junior year there?
No, I didn't finish my junior year. I was actually on online schooling.
Okay, but once this is all done and we get to the start of the new school year, you'll be at Tri-Cities?
Yes, sir.
For your senior year?
Yes, sir.
Okay.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Are you a United States citizen?
Yes, ma'am.
Do you understand that you're charged with the following offenses in indictment 24 SC 005867? It is 1 count of burglary in the first degree, count 2 theft by receiving stolen property, count 3 financial transaction card theft, second count of financial transaction card theft, possession of a firearm for the commission of a felony, and possession of tools for the crime.
Yes, ma'am.
Do you understand that you have the right to either plead guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may dispute your trial.
Yes, ma'am.
Have you had enough time to speak with your attorney, Ms. Rios, about all the facts and circumstances known to you regarding the charges of this indictment, including any potential defenses?
Yes, ma'am.
Do you need more time to discuss this case with your attorney?
No, ma'am.
Are you satisfied with your services?
Yes, ma'am.
Ms. Rios, you waive formal reading of the indictment and any non-effects for the purposes of this plea?
Yes.
Mr. Martin, do you remember being arrested for these charges?
Yes, ma'am.
Your Honor, the state's unaware of any outstanding warrants related to these charges. Ms. Rio, are you aware of any outstanding warrants?
No.
Mr. Martin, has your attorney advised you of the minimum and maximum sentence for each charge to which you're pleading today?
Yes, ma'am.
Do you understand if you plead guilty, if your plea is a blind plea, also called a non-negotiated plea, the state may still recommend a sentence to the court?
Yes, ma'am.
Do you understand that the court can impose any sentence authorized by law, including a higher sentence than that recommended by the state, up to the maximum sentence on each charge?
Yes, ma'am.
Do you understand if you're, that this is a guilty plea that will permanently be reported in your courts?
Yes, ma'am.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as other jurisdictions, including in federal courts?
Yes, ma'am.
Do you understand that if you're not a United States citizen, a guilty plea will affect your immigration status and will result in deportation, just like a conviction at trial would, and this is true regardless of any advice by your attorney or anyone else?
Yes, ma'am.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you'll be guilty of a felony, which may carry a sentence from 1 to 15 years in prison?
Yes, ma'am.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following trial?
Yes, ma'am.
For example, your guilty plea may affect your right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes, ma'am.
Do you understand that you waive any and all defenses, including mental health defenses, by entering a guilty plea?
Yes, ma'am.
Do you understand that by pleading guilty, you're given up the following rights: the right to a trial by jury,
Yes, ma'am.
the right to remain silent and not incriminate yourself,
Yes, ma'am.
the right to confront witnesses against you,
Yes, ma'am.
the right to the assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial or case,
Yes, ma'am.
the right to the presumption of innocence,
Yes, ma'am.
the right to testify on your own behalf and to present other evidence,
Yes, ma'am.
the right to subpoena witnesses and to compel the production of evidence,
Yes, ma'am.
the right to have the charges against you proved beyond a reasonable doubt,
Yes, ma'am.
the right to appeal a conviction of these charges after a trial.
Yes, ma'am.
Do you understand that you may have only a limited right to appeal this guilty plea conviction?
Yes, ma'am.
Do you understand that you have only 4 years from today for a felony charge to file a habeas corpus petition challenging the voluntariness of this plea?
Yes, ma'am.
How do you plead to the charges in indictment 24 SC 005867 to the count of burglary in the first degree, theft by received and stolen property, financial transaction card theft, 2 counts, possession of a firearm during the commission of a felony, possession of tools for the commission of a crime? How do you plead?
Okay, guilty under Alfred.
When forced, threatened, or promised you anything against you to enter a guilty plea?
Amen.
Is it your decision to waive these rights and enter a guilty plea because you're in fact guilty?
Say that one more time, ma'am.
Is it your decision to waive these rights and enter a guilty plea because you're in fact guilty?
Guilty under Alfred.
Is this plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
At this time, we'll provide a factual basis for this plea. Your Honor, on September 10th, 2024, officers were alerted to a vehicle that had been reported stolen out of Sandy Springs. It was a 2022 Toyota Sienna. Officers approached that vehicle, which they thought was unoccupied, but it had 3 individuals located within inside that vehicle who were sleeping. One of those individuals was Mr. Martin. While they were attempting to detain the individuals, Mr. Martin had a silver Ruger handgun that was located next to him, as well as a crowbar. Officers interviewed Mr. Martin. He was Mirandized. They did speak with him about this case. They also located 3 sets of financial transaction cards on his person.
one belonging to Ms. Angelica Smith. It was a Capital One card, Saks Fifth card, Sam's Club card. They also located cards belonging to Mr. Leon Blue, a Capital One card and a Navy Federal card. And third set of cards, Mr. Joseph Wilson, which was a Visa card. Mr. Martin stated that he stole the cards from somebody who originally stole them. Officers were able to make contact with the victim, Ms. Smith, whose home had been burglarized the day before on September 9th. There was ring camera footage that captured the individuals who were surveilling the property, circling the property, and ultimately entering into the property, taking some items, including the cards and some other items. Officers were able to locate some of that clothing in the backpacks of the stolen vehicle. And that was the actual basis for it.
All right. Can you give me the minimums and maximums for the charges, please?
Yes.
Oh, you have to get a different book. While you're looking those up, let me get criminal history information, if any, from Ms. Jackson.
There are no priors, Your Honor.
All right. Ms. Rios, while Ms. Davis is getting those, tell me why this is an offered plea.
Yes, Your Honor, because the offered plea is to the other charges, the financial transaction for the cards that he had on him. He's admitting to those, that's a regular guilty plea, but the other charges, he's saying that he was just picked up with these group of boys. They had the stuff in the car, he saw the cards in the car, took those, but he's saying that he wasn't the original person who was involved in the initial breaking in. So that's why it's an offered plea, Your Honor.
Got it. He's saying he basically came late to the process of the burglary. It was over. He was in this stolen car with, he says other boys, although one of the co-defendants is a female.
Well, yeah, I said other boys. I'm sorry.
Oh.
I was thinking they're all boys, but yes, there's one's a girl, I believe.
Miss Bernard, right.
Right. So that's why he's pleading to that, but he's admitting to taking the cards and that's
Okay. The gun and the crowbar,
just in the car.
they were in the car. Okay, got it. But he is entering this as an offered plea because a jury might say, of course, you're saying you came later, but you were in the car with all these things, and that's circumstantial evidence that he was a participant.
Yes, Your Honor.
Got it. Okay.
Should I say the other stuff I want?
You can, if we're ready with let's get the minimums and maximums first.
For the burglary, it would be 1 to 20 years.
Mhm.
For the death by receiving, 1 to 5 years.
Okay.
It's actually 1 to 3. The financial transaction part for 1 to 3 years. The possession of the firearm is 5 years consecutive, and possession of the tools is 1 to 5 years.
1 to 5. Okay. I think the car would be at least 1 to 5 because it's 25,000 or more is the value. So I wasn't sure. Okay. It sounds like the burglary has the biggest range. Okay. Thank you. Anything you want to say now?
Yes, Your Honor. He is working, I know I provided the one job he's working at, which is a Shake Shack, right? What were you? Yeah, but he also is doing construction and HireQuest. Is that where you HireQuest? It's a temp agency. Right? Yeah. So he's he's been working hard since then and trying to get back to school. So he's been on the right path. His mom wasn't able to be here, but I sent she wrote a note that I sent, and his dad is here and has been coming to his court date. So I think his parents have him on the right track. And so I'm asking for him to have 5 years probation on the other charges that are not the gun charge, which has to be the 5 years consecutive, with a 3-year behavioral incentive date. This would be his first felony. So I'm asking for him to be treated as a first offender.
Ms. Davis, I think, again, you didn't say what the state's recommendation is. Okay.
The initial offer was 1 year to serve, and we will stick with that recommendation. based
Oh.
on the facts.
Okay, so that would address all the counts except for count 5, which has to be 5 years consecutive. So how do you structure the whole thing? Is it a year to serve plus 5 probation plus 5 suspended?
5 years served, 5 years probation consecutive to the initial term.
So
Basically, a total of 10 years.
got it. Okay, so 10 years to serve 1 balanced probated. All right, got it. Any conditions of probation?
Inside the horse, and some community service, there are 160 hours community service.
Okay. I'll say no contact with victim and stay away from that residence that was burgled. All right. Restitution, is there, it sounds like these things were recovered. Is there additional restitution or not?
This time, I believe the items were returned. I would ask to preserve it if you do receive some new information.
Okay. Trying to read the letter from mom. It's just, it's small, so I'm making it big. Go. So your mom says that you've been at Waffle House and Shake Shack?
Yes, sir.
Are you at both right now or?
No, sir. My Waffle House was my recent job. Now I work at Shake Shack in Midtown.
Okay. What happened to the Waffle House job?
Shake Shack is a better job, so that's why I left.
Oh, so you left for a better, like it pays better or it's better hours or whatever it is?
It's like pay better, than also they'll give out like, mental and like insurance and stuff. So it's like better opportunities.
Better benefits. Okay. And how long have you been at Shake Shack?
For about 3-4 months now.
Okay. And it's the one that is, you said in Midtown?
Yes, sir.
What's that near?
By Pavement Park.
Okay. Okay. Anything else, Ms. Rios?
Your Honor.
Mr. Martin, anything you want to add?
I would like to say that I know like, first of all, what I would like to say is that I want to do a lot of stuff in my future, and I'm not trying. I know you hear this every day, but I'm actually being serious about my life. I want to actually finish high school, and I don't know if you're seeing on there, but I'm actually planning on to join the Army.
I saw your mom mention that.
Yeah, this is not me saying nothing. I actually just want to have like a better future, Yeah, that's all I'm gonna say though.
Okay. How did you know Ms. Bernard?
That's the thing. I didn't know. I don't know if you guys had wrote what I had told the police or anything, but all them people that was in the car, I basically didn't know none of them. The only reason why that I interact with them is because people who I know that they know, but everybody who was in that car that I don't really know too much about them.
Okay. So why'd you get in the car?
Because one of the other persons, well, I forgot all their name and stuff, but if you like meet somebody and that they're cool and stuff, I didn't know that was a stolen car at that time, and I was actually picked up because whatever the burglarize or whatever that was, that happened after the fact. Well, actually before the fact.
Before the fact,
Yeah,
right.
before the fact that I was even like picked up or anything.
So you got in the car and it already had the things that had been taken from Ms. Smith's house.
Yes, sir.
Okay. And you put into your pockets some of the credit cards.
Yes, sir, which was done.
It was. So Mr. Ross is the other defendant you've got. Is he in the same category as Ms. Bernard, that you didn't really know him before getting in that car, or that's one of the guys you knew who introduced you to the other people?
I don't know which name is,
Mhm.
but I yeah, Ross. I think that's his name or whatever. But he was just the person that I had met that I was cool with and stuff. And like 2 days later, he had hit my phone up or whatever like that and said, "Oh yeah, we got a car or whatever. You want to go and like, you know, party or whatever like that." And I was like, cool, what's wrong with that and stuff. So yeah, but all like the people who basically what I'm saying is I didn't know Ross I would just now be able to know him and stuff.
Okay. The way the officer described it, when they came across the vehicle, everyone was asleep in it. Is that what you remember? Is that you were asleep in it?
Yes, sir.
So how long had you been in it?
Well, just like I said, the driver, I didn't know who was ever the driver, but he was going upstairs to get up something, like whatever he was doing and stuff. So just like I said, I didn't know that was a stolen car. So of course I'm gonna be going to sleep. I don't think nothing of it.
Oh, so the driver had parked the van and is gone for a while and you guys are there. So you just fell asleep.
Yes, sir. Because all that's on your case and stuff, that's my co-defendant. We were just all in the back and stuff. And,
Okay.
Yeah.
And the driver doesn't sound like he got arrested. Maybe he decided not to come down to the van when the police were there.
I'm sorry.
Okay. All right. Anything else?
No, sir.
I wasn't sure if Dad wanted to say anything. Did you want to say anything?
Okay, you're very stuffy, but I'm glad you're here. It's a good sign to have parental involvement, and it was great to get that letter from Mom as well. So, okay. Mr. Martin, I find there's a factual basis for your plea, and that your plea is knowing and voluntary. Knowing means you've understood what we talked about. Any questions about anything yet?
No, sir.
Okay, voluntary means no one's forcing you to do this. You've decided that entering a plea is the way you want to move forward. Is that correct?
I would like to hear the plea first, and if I don't like it, I would love to take this to trial because I feel like, you know, that.
That's what he explained. So
Got it. No, we're saying the same thing. Your answer makes sense, and you want to hear the sentence that I'm going to impose, and you'll see what you do with it. I am sentencing you pursuant to the Probation Options Management Act. And what that means is that when you're on probation, and both sides have asked for some probation, if you have any issues on probation, and I hope you have none, but life can be complicated. If it's a small problem that you had, you and probation will resolve that. I don't have to get in the middle of it. But if it's a bigger problem, you get arrested for something, that comes back to me. Ms. Rios, can someone in my office sign the indictment for you?
Yes, sir.
Ms. Davis?
Yes, Judge.
Mr. Martin, is it okay if we sign your name on the indictment?
Yes, sir.
Okay. You are pleading as an offered plea. That's when a defendant says, I didn't do everything the state says I did, but I don't want to run the risk of going to trial. That sounds like your situation. You're saying, you got me. I had those cards in my pocket. They were not my cards. I knew that. But you're also saying, look, I want my gun, but I'm gonna plead because it's just this seems like right now, at least based on what my lawyer's arguing for, a better outcome. Do you agree with that?
Yes, sir.
Okay. Ms. Rios has asked to have you sentenced as a first offender. That is something you're eligible for because you have no convictions. You didn't have any arrests or anything as an adult. First offender means that this is not a conviction. So if you're trying to go back to school, get in the military, keep working, and you got to fill out a form where they say, hey, are you a convicted felon? The answer will be, no, I am not. Even though you're under sentence, it's a first offender. That's not a conviction. And the benefit of it is if you successfully complete your sentence, it's all wiped off your record.
Yes, sir.
The risk is that if things don't go so well, and I'm making this up, but 6 months from now, you get arrested, you got a stolen this or a stolen that or drugs or whatever, and that includes a gun. You cannot have any guns around you while you are on first offender probation. If you get arrested for something, not only do you have that new charge, but you will be back in front of me, and the state may ask, or I may decide on my own to say, you know what? You told me all this stuff, Mr. Martin, that you're serious. And yes, I hear it all the time, but you're different. You're going to the military and you're working hard. You're going to do the right thing. And that was all a big song and dance because here you are again and you were in trouble. I can, without a trial, because you've already pled guilty, say, I am going to revoke your first offender and resentence you as a convicted felon. And Ms. Davis gave us all these ranges. There's some big numbers in there. It could be 25 or more years that I would sentence you to. I'm not going to do that unless whatever you did was particularly bad. But if you get arrested for burglary again, then I'm probably going to take away your first offender and say you told a story that's not accurate. And then I would resentence you to some years and you'd have to go deal with that. Now, you don't need to worry about any of that if you are, in fact, legit and you aren't going to get in trouble again. But I need you to tell me you understand the risk of first offender. If you mess up, it bites you pretty hard. And the benefit of first offender, which is no conviction. And if you get through this, it all comes off your record.
Yes, Your Honor. I'm gonna say, God forbid, I do not want to get no more in trouble, but yes.
You want to be sentenced as a first offender?
Yes, Your Honor.
Okay, I will do that. So, Mr. Martin, I am going to sentence you as follows. On count one, I am sentencing you to 1 year. Count two is 1 year. 3 and 4 are also 1 year. 5 is 5 years. It has to run consecutive to count one. And count 6 is 1 year. So it's a total sentence of 6 years. Give me 1 second. That 1 year is 1 year to serve 2 months with a balance on probation. So that's 10 more months of probation for that 1 year plus 5 more. That one gun charge has to be consecutive. So the total sentence is 6 years to serve 2 months with a balance on probation. Special condition of probation number 1 is no contact with Angelic, that's with a C, Smith. That's the young lady whose credit cards you had and whose house was burgled. Also, no contact with your co-defendants. It sounds like you didn't really know them, but insofar as Mr. Ross calls you up in a year to say, let's go kick it, not with him.
Yes, sir.
And no contact with Ms. Bernard either. Special condition number 2 is take an anti-theft course. And number 3 is that you'll complete 75 hours of community service. You'll work with probation on where to do that and how to do that. I don't mean for that to be you picking up trash on the side of the road. It can be, but you are a very well-spoken young man and there may be community service where you're working with kids who need help or who knows what. So I encourage you to talk with your probation officer about ways you could do community service that's more like volunteer work at a place that would benefit from you volunteering. I think that's it. Oh, and I'll set a behavioral incentive date of 3 years from today, which is June 11th of 2028. What that means is if you successfully complete the first 3 years of probation, there aren't any big hiccups. Probation can say, let's close this out early. And I'm happy to do that if that's their recommendation. So you can shave a few years off by doing real well up front.
Yes, Your Honor.
Ms. Rios, anything else in connection with Mr. Martin's case?
No, Your Honor, thank you.
Ms. Davis, anything else?
No, Your Honor.
All right, any questions, Mr. Martin?
No, sir.
So my sentence, I think arguably is different from Ms. Rios's. She had 5 years suspended and 5 years probation, and I actually have 5 years and 10 months probation. Do you want to talk with your lawyer about whether you want to go forward or not?
Yes, yes, sir.
You want to talk with her first?
Yes, sir.
Okay, chat with her, and then we'll get back on the record and you let me know what you want to do.
Just to make sure I understand it too, the sentence is total 6 years,
To serve 2 months,
serve 2 months, and then.
credit for time served, and then the balance is on probation. That's how I got 5 years, 10 months probation.
It's just 10 minutes longer. We could talk.
Oh, okay.
You
Yes,
get it
I
now?
just had to make sure and had to clearly understand, but I clearly understand.
You do? All right, I'm not, no one's rushing you. You feel like you understand
Yes, sir.
and you want to go forward with it.
Yes, sir.
Great. What county do you live in?
Fulton County.
All right, in just a moment, you're going to talk with Ms. Simpson, who's seated there in the jury box, about when and where you report for probation. It won't be today, it'll be in a few days, but you don't want to miss that first date. I just today, while someone else was pleading, signed a warrant for a guy who didn't show up for his probation intake. What a dummy. You can avoid that, okay?
Yes, sir.
All right, good luck with everything.
God bless you. Thank you.
Hey, you too.
Judge McBurney,
Ms. Davis.
I have a question for you.
Mhm.
So you allow for things to first offender sentence?
I do, it depends. And I guess I should have been clear for Ms. Nelson. This was an offered plea as to only some of the counts. Yeah, let me get the indictment up. It's an offered plea to 1 and 2 and 5 and 6, but not to 3 and 4. Thanks. Does that surprise you that I do offered pleas and first offender?
Like, look at my trustee Bible book here, and yeah, so I thought that only first guilty, but now it's guilty and no low, so.
Yeah, so it happens sometimes. If I'm usually less focused on the offered and more on the first offenders, like, is this a good fit? Do they qualify? That kind of stuff.
Yeah.
Yeah,
Thank you, Judge.
you bet. So Mr. Abate was back for a little while, and then he was gone again. What are we doing with Mr. Davis? Okay, is there another plea you want to take first?
Well, Mr. Davis has family here.
Okay.
So, but I'm ready on Larry on Williams as well.
Well, let's see, Ms. Dilligar is going to step outside. Maybe Mr. Abate's right outside? Okay, I'm assuming he is scrambling to connect with the victim's family? Okay.
So I can do Larry on Williams.
But he may come, if he comes in and if he says, look, I need 10 minutes to talk to the victim's family, then we do Larry on Williams. If he's ready to go, I know Mr. Davis, I think it's his mother who's here. So I'm all for taking care of that.
That was negotiated. Yes. And then the other. Try to do this like this.
I was really continuous since we realized that was January last year. He was here and we got revoked.
Mr. Abate, Ms. Wood says that Mr. Davis is a plea.
I just learned.
Okay. We earlier today had a surprise plea and Ms. Davis understandably said, this is a case where 2 people were shot. It's actually 2 cases. And so we do the guilty part, but we were deferring the sentencing so that she could reach out to see. That's one where finding the victims might be a little complicated. Are you comfortable going forward with the full plea as in sentencing as well?
So I was going to request exactly what Your Honor just outlined as it relates to if we move forward with a plea where he accepts, you accept the guilty plea, then we do sentencing at maybe Thursday or another day. I know the victim's daughter as well as her husband would both very much like to be at least on the Zoom or present. I know the daughter lives here.
Pardon me?
The daughter lives in Atlanta. But
Got it.
the husband now lives in Maryland.
Okay.
He can join via Zoom.
Okay. Ms. Wood, is that going to complicate things? Or what we would do today is, and if it's negotiated, we can get on the record what it's not negotiated?
I may need to talk to Ms. Woods because he is a recidivist. And I've filed a recidivist notice. He's A and C, which makes him a mandatory life without parole. But if he's willing to take life plus 25, I would remove the recidivist notice where he pleads, get sentenced to murder, dependent 25 on the rate, aggravated.
Ag sodomy.
Just to complicate the issue, I guess I'll alert the court. Today, we got word from the GBI where there was another rape in which this defendant was arrested for. around the same time as the murder. The DNA has come back, and it's a hit, or a match to this defendant. It's a rape that occurred about a month prior to this aggravated sodomy and murder. So obviously my intention was to reindict and add the rape from the month before to this indictment. We're so close in time.
But it's not the same victim.
It's not.
Okay. All right. So that's a complicating factor. If Mr. Davis wants to go forward with a plea today, it wouldn't be to uncharged conduct. What do we need to get on the record, that there's another case out there, or if you,
I guess I was just informing the court there likely will be if he pleads today, there'll be a new indictment for the rape.
okay, unrelated to this?
Yes.
Okay.
A month prior to, so I think they're close enough in time. I could put them on the same indictment without them being severed, because it's almost equates to something like a spree.
Okay, but we don't need to navigate that today because that CODIS hit just came in. Okay. Ms. Wood, tell me where you think we are in terms of going forward, having heard what you heard. Not so much that last part about the CODIS hit, but hey, he's a recidivist, and so we'll withdraw that if he pleads to this and that. I don't know what the 4-pack was talking to him about and what he's expecting.
He understands, I think, even though I was in the hallway for the actual final plea hearing, he understands the gravity of the situation, and that's why he was eager to accept responsibility and take care of his case. Now, I was aware, I knew about the unindicted case in court.
Okay.
So we were not planning to have that looped in at all at this point, and he knew that as well.
Okay. All right. But it sounds like the state is willing to withdraw the recidivist notice only if Mr. Davis is agreeing to a certain term. And if he's not, which is 100% his right, then I wouldn't have an option but to sentence him to life without parole. So that's the only, I don't want it to fall apart partway through because wait a minute, no, I thought, Ms. Wood, you were going to recommend life and then whatever the minimum for ag sodomy to run concurrently. And that's a different set of numbers than what Mr. Abate just said. But if you think Mr. Davis is prepared to agree to the sentence Mr. Abate said so that the recidivist notice can be removed, then we ought to go forward. But it's not non-negotiated wouldn't work here because the state holds all the cards. And
Right.
if it's non-negotiated, they're not withdrawing the recidivist notice.
And that's my misunderstanding, Judge. I think I was forgetting about the recidivist notice not being withdrawn.
Okay.
So then that changes things, obviously. To final plea hearing, did we make it through all the way, or?
I have not spoken to Mr. Davis really at all. He came out here and Ms. Gerber said, oh no, he said, I want to work the case out. And Ms. Gerber's eyes got really wide and we said, okay, you know what you're charged with. I know. And so she said, could I talk to him more? And then Primovic showed up and you showed up. I mean, it started getting, it's escalating. So we had zero conversation. It was, hey, Mr. Davis. And he said, I want to work the case out, which I now understand a little bit better. Why? So I don't know if you need to talk to him again. I feel bad if Ms. Gerber's left now.
No, I'm.
Oh, she's hiding.
I'm hiding,
Okay.
trying to be within good,
Got it.
you know, whisper
Okay.
distance.
Yeah, anything to not be involved with this case. Why don't you guys chat with him one more time? But Mr. Abate, am I understanding correctly? You're withdrawing the recidivist notice if Mr. Davis pleads to life plus 25. That is, in theory, parolable. The parole board would do what it does with a life plus a consecutive 25 that's not parolable. So I never know what the parole board's going to do. And if you read Ms. Gross's article recently, they just leave you in jail anyway. But that was her article. So that's sort of where we are. I just don't want to invest your time and his mother's time in 20 minutes of a plea colloquy. And then he says, wait, what? No, that's not where I am. So why don't you guys chat with him briefly and then we can do it. But what we would do is lock in the state's commitment that that's their recommendation. But we would have the actual sentencing when the victim family members could be here. The state wouldn't be able to say, gosh, now that I've heard from the victims in this way, we want life plus 100. They would have committed to what their recommendation is. Okay. I know, I won't. I think we have one more plea. Larry on. I was not expecting this one. Harris plea. And we have to bring Mr. Ross to the door. Plea. Oh yeah, and Gould. Oh, we're doing Gould. Thank you for spraying that down. Man, that sound was bad. It's a whipped cream. Like, you don't want to spray whipped cream over it. I kept looking, I was like, is that Dilligard? That's so gross. How is she doing that noise? It is not ladylike.
Mr. Harry, he just was sneezing and.
The dad, yeah. It was, I don't know if it's allergies or the plague. All right, I'll be right back. We got another one?
This is like the surfaces.
Oh, I thought that's what he used.
That's like air.
Oh.
This is the.
Okay, I'll come back.
Okay. So it smells good, but it's still crawling with whatever he had.
Yes.
We still going. Yeah. I know that. Okay.
Yes, all that. Last plea, he just paid his dad. It was all congested, oh God. Oh, and you couldn't hear it. Oh, you were the first time. Yeah. Did you, what happened in the hip? Right. It's happened when we were taking that in the guys. But we had to be doing it. Like, is there? Yes, we're still.
Outside voice. What are the new gloves for? Oh. Oh. So it protects them. Got it. You don't want to get that all over.
Yeah.
Yeah.
So what I'm working on now. So. This is what it is. And now we're doing really much more good. And I just think it's a pretty, I don't have a kid. Right now, so I can stare at what I'm doing. You do something down. Start a day next week. I tell your mom, she grounded, but she is managing our 75 issues. Organizing our mock for court actions. Yeah, when you, so you don't know you pass the 17. Then I don't have a business right. Okay, so we took out there's the 17th, and I'll be with this to you. Because Monday's the 16th, right? Yes. Yes, it's the 16th. And we have to know like the first. To something else. Yeah. But she's like, I think that's all. You can't get a good time. It helped me out last. So this happens, we can only have. I think probably like he might have something. They might have something this week. Once
No, they're in their files. I'll look at them tonight. I mean, I looked at who's getting sanctions. For who? Well, unless he is, maybe they changed, but what I read on the thing that Ms. Johnson sends out is that he could come back for a third time, but it would be straight to residential. No, he was at supportive housing. So I think they're saying, we'll give you a third, but it's straight to Hope House. It clearly needs it.
Well, I looked at him and was like, oh, he just got back.
I know. To me, it seems like more like RSAT, but,
And then maybe, because I mean, he came back. He did say that he was having some issues.
yeah.
I saw that.
I know. And some of these folks, we kind of do a lot to get them out, and then they just, come on, people.
I'll maybe just go away. I'll just be used to that and then you don't want to around with that.
I know, I just wrote it down. The first offender was something that Alfred was 1, 2, 5, and 6.
can't read my own. It's all over the place. Where did I see it? Yeah. I did believe that I had a trouble. Yes. As I was so. What? I'm doing it. That's all. Yeah. That's just my story. A lot of people want to still try to no, like how we treat I can't remember that. She let me know. He's like he thinks it's the best of that, so he and anything I feel like we could have for clean. So you mistakes. Yes. He is position. He's on the supplemental final plea, position 4.
You're looking for Mr. Davis?
Mr. Larry on Williams.
Oh, Larry, that's a plea. Yeah.
That's a plea.
That's I think the last one. And then we can.
We haven't done it.
Too bad.
She's there, rabbit. Well, he probably has failure to appear, but he must have another litigation besides the bill.
Well, he's got
Maybe conservative brother.
we don't have anything holding.
I'm
gonna show you what I see.
But the parents not him.
Yeah, we don't have anything. Just
No, maybe we can closer to
this.
Yes. The both of them. There.
Oh, and she.
That's not bad.
Yeah, this case was everything they overlooked.
I'm still doing the same.
It did.
Don't get all it, like, the police office, we don't have all these, like, people that's actually trying to solve.
That's not.
Yeah, I want to, I sign us, but
I know, I think y'all.
I have no talent.
Y'all can do that.
This. I think it's all about illegal. Like, I really feel it's really nice. Maybe I could draw some families and sell them.
I know. A lot of this thing.
I mean, it would be good. I think it's so good.
Since
I thought count one could be,
You said 1 year, just.
they were all 1 year to serve 2 months.
Oh.
Except the one gun count that was 5 consecutive.
Okay.
This really is an actual letter for. I'm trying to do it out 10 days later.
Hey, yours for tomorrow. Hopefully it won't take too long.
Yeah, it
You have a
should.
general question.
Yeah. I did talk to her again. She's gonna be 100% honest, so it should go smoothly.
Your Honor, I'm gonna let Ms. Woods handle it since it's escalated a little bit.
I appreciate all the work you put into it. Ms. Wood, what is Mr. Davis's election?
Judge, so we would like to remain on the July 10th trial calendar. Again, I don't think this will actually be a trial. If the court could just explain to him, he's very nervous about the fact that the title of today's calendar is the final plea. I've expressed to him that the court will accept a plea basically at any point between now and then. And so we're gonna just keep working. I'll keep talking to Mr. Abadi.
You bet.
See what we can do.
So, Mr. Davis, first, let's get on the record. So we'll make a record of all this. This is 24 SC 006492, and today is your final plea date. That is a little misleading in the sense that it makes it sound like maybe you could never plead again after today. That's not what it means. You could reach out to Ms. Wood tomorrow and say, let's do this, because I know the state has made an offer, and right now it's not one that you're prepared to accept, and that's fine. You could plead the next day. You could plead the day of the trial calendar, which is July 10th. You could be 2 days into your trial and you could enter a plea. You can enter a plea anytime you want. What changes after today is only one thing, and that is your ability to withdraw or back out of the plea if the sentence that I impose is higher than what Ms. Wood asked for. So just as an example, using your charges here, the state, it sounds like had offered to, well, I'm gonna keep it simpler. The lowest sentence that Ms. Wood could ask for based on what you're charged with would be life plus 5. If that's what she asked for, if you said, I'm pleading guilty, I did these things, I'm gonna deal with it. And Ms. Wood said life plus 5, but Judge, I want you to suspend those 5 years. So it's a life sentence, which would mean 30 years before you're eligible for parole, but you are eligible for parole. And then those 5 years are suspended. I would hear from the state, they might recommend something different. And if today I were to say, you know what, I'm gonna give you life plus 10. This case, to me, it disturbs me. I think life plus 10 is the right sentence. You could say, no, thank you. I was willing to do life. That's what my lawyer asked for. You've given me a higher sentence. Appreciate it, Judge, but I'd rather go to trial. You could back out of the plea. After today, you can still enter a plea, and Ms. Wood can still advocate for you and say, Judge, this is what you should do. But if I give you a sentence that's more than what Ms. Wood asked for, that's the sentence you're stuck with. It's really just like if you went to trial. If you're found guilty at trial, Ms. Wood's going to argue for a sentence. You don't get back out of the trial if the sentence I give you is different from what Ms. Wood asks for. Does that explain? The only thing that changes from today is your ability to back out of the plea. You can still enter a plea tomorrow or the next day, all the way up through trial time. Does that make it clear, or did I make it worse?
Oh, sir.
Which one? Did it make it clearer or not?
What? I just wanted to know, will I be able to come up for parole?
So that's a different question. And for you to be eligible for parole, the state has to agree to, they have filed a document that highlights some trouble you've already been in. And if they don't withdraw that, then I'm required to sentence you to life without parole, if you plead or if a jury finds you guilty. If they withdraw that, and they were willing to withdraw it today, and they might be willing to withdraw it tomorrow or some other time, then I don't have to sentence you to life without parole. What the state had offered today was life plus 25 years. I don't know what that math means as to when you'd be eligible for parole, but somewhere in there is a parole window. It might be a small window, but there was a window. The state controls the whole parole eligibility right now because they filed that notice that's based on your criminal history. So that's one of the things Ms. Wood would need to negotiate with the state, would be to get them to withdraw that recidivist notice.
So you saying after this, can I still take a what's the name, a plea?
You can still take a plea. I don't know what the terms will be, but you certainly can do that. And I'll tell you, generally, a defendant who is willing to accept responsibility, not put the victim's family through the difficulties of a trial, because they'll be watching, they'll see pictures of their wife, their daughter, however this young lady was connected to them, sitting on a coroner's table, and they don't want to have to look at that. Someone who pleads guilty, generally the state, they'll offer something up. And here it may be, I'm not promising you this because I don't control it. It may be that they withdraw this recidivist notice so you will be eligible for parole. But you'll know going in, there will be no surprises. We don't do pleas and wait, no one told me this or no one told me that. The one thing that changes after today is just that you don't get to withdraw your plea if you're unhappy with the sentence you get. That's it. Does that make sense?
Yes, sir.
Okay. So what Ms. Wood has told me is that she's going to keep negotiating on your behalf, see what she can line up. I will see you at the latest 1 month from today. That's when we are doing your trial calendar. That'll be another opportunity to resolve the case. It might happen before then. If there is something worked out and you say, let's do that, and we can get you in before then. But otherwise, I'll see you on July 10th, and we'll see if Ms. Wood has been able to negotiate something that you're interested in pursuing. If not, we can always do the trial. You have a right to that. And I know you may not be interested in the trial, but really the victim's family has a right to the trial as well. If you guys can't negotiate something, then we don't just say, let's come back in a year. We say, well, then we should go to trial because there's not a middle ground for these two sides.
Yes, sir.
Okay?
Yes, sir.
Ms. Wood, anything else on behalf of Mr. Davis?
No, Your Honor, thank you.
Okay, so I find that Mr. Davis understands what the state was offering. He's not interested in that at this point. So we'll move his case to trial. He could always enter a plea tomorrow or the next day. He just can't withdraw that plea if he is dissatisfied with his sentence. Mr. Abate, anything you want to get on the record in Mr. Davis's case?
Nothing other than the fact that the state will only be withdrawing the recidivist notice on a negotiated plea to the numbers we spoke about, the life plus 25, which would all be parolable. If the recidivist notice remains in place, then it would be required to receive a mandatory life without the possibility of parole, plus an additional life sentence for the aggravated assault, which is the maximum as relates to that.
Okay. I don't know that the 25 is parolable. I don't know how that math would work if the 25 is keyed off the aggravated sodomy, but I don't want us to dive down that rabbit hole right now. Your point was a helpful one, that the state will withdraw the recidivist notice if there's a plea to the parameters you shared.
You are right. 25, I guess, is not parolable, but I said that in the sense that a life sentence typically, in order, someone is not, according to the guidelines at this time, is not eligible for parole until they've served approximately 30 years, which is why I said it the way I said it, but I'm glad that you corrected the record by all means. But that's the terms of the state.
Right. There's a possibility of parole if there's a negotiated plea. If there's not a negotiated plea, if Mr. Davis is found guilty at trial or puts up a blind plea, there's not a possibility of parole. That's a pretty clear distinction. Okay. Mr. Davis, I will see you soon. Ms. Wood is going to continue working hard on your behalf. She'll be in touch with your mother and certainly with you, and we'll see where we go. Okay?
Yes, sir.
All right.
God bless you, sir.
I'll see you soon, Mr. Willis. Thank you, Judge.
You bet. Can we bring Mr. Williams out or do you need a minute?
Yes, Judge, I'm ready on that one.
Okay.
Yeah, a lot of rules today.
Yeah, there was a different one than from the guy who woke up in the stolen car. His DNA is not running around a bunch of victims. Yeesh. Mr. Williams, come on up to the podium, please. Ms. Dilgard, do you know where your successor has gone? Okay. You don't need to interrupt that.
She did tell me she was the rest of the side.
Okay.
Standing so far away.
My apologies, should I?
It's not a problem. Not a problem. It's been a long afternoon. Let me know when you're ready. Okay. We'll go on the record. This is 24 SC 003440. State versus Larion Williams. Mr. Williams is in court with Ms. Wood. Ms. Davis is here for the state. And Mr. Williams, Ms. Wood tells me you are ready to enter a plea. Is that right?
Yes, sir.
Okay. Ms. Davis is going to put you under oath, ask you some questions about your rights, and I'll have a few questions and we'll go from there. I need you to let me know if you ever have a question. Will you do that?
Yes, sir.
All right, Ms. Davis.
Please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
I do.
You can put your hand down. State your true, correct, and legal name.
Larion George Williams.
Can you spell your first name for the record?
Larryeon.
Thank you. Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No.
Is there any medication that you normally take that you have not taken today?
No.
How old are you and how far have you gone in school?
I'm 22, 10th grade.
What high school did you go to?
I went to Riverdale.
Are you able to read, write, and understand the English language?
Yes.
Are you a United States citizen?
Yes.
Do you understand that you're charged with the following offenses in indictment 24 SC 003440, armed robbery, aggravated assault, possession of a firearm during the commission of a felony, and possession of a firearm by a convicted felon?
Yes.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes.
Have you had enough time to speak with your lawyer, Ms. Wood, about all the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes.
Do you need more time to discuss this case with your attorney?
No.
Are you satisfied with her services?
Yes.
Ms. Wood, do you waive formal reading of the indictment and any and all defects therein for the purposes of this plea?
So waived.
Mr. Williams, do you remember being arrested on these charges?
Yes.
Your Honor, the state is unaware of any outstanding warrants related to these charges. Ms. Wood, are you aware of any outstanding warrants related to this case?
No, I don't think there's anything out there for this case.
Mr. Williams, do you understand that today you are entering a negotiated plea of guilty, which means the state will recommend the following sentence to the court? It will be a probated sentence, and if the court doesn't mind, I would save it to the end, or I could say it now.
As long as you share during your presentation what the recommend, I just need it at some point during your presentation. I guess we'll need to, are you dismissing certain charges? If we're getting to probation and we've got an armed robbery charge?
No, we're not dismissing certain charges. We are doing a slight deviation from the minimum pursuant to 17, I believe 10.6.1.
Yes.
It'll be
Okay.
13-7 for the armed robbery.
Where's the probation part?
The balance of that term would.
So it's actually 7 to serve in the.
Yes.
Okay, I misunderstood. I thought you were saying this
7.
sentence was straight probation. Like, that's a big deviation. Got it. Okay. Thank you.
Mr. Williams, do you understand that the court is not required to accept the state's recommended sentence?
Yes.
Do you understand that the court has the right to sentence you to the maximum possible sentence on each charge?
Yes.
For count 1, the maximum sentence is 10 to 20. For aggravated assault is 1 to 20 years. For possession of a firearm during the commission of a felony is 5 years consecutive. And for possession of a firearm by a convicted felon on the second offense is 5 to 10 years. Okay. Do you understand that there are multiple charges to which you're pleading guilty to today, and the court has the right to run those sentences consecutively or one after the other?
Yes.
Do you understand that if the court decides to order a sentence that differs from our negotiated plea that you were expecting today, that you have the right to withdraw your plea today?
Yes.
Do you understand that if you're placed on probation or parole of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes.
Do you understand that while you are on parole or probation, you're not allowed to possess or use a firearm?
Yes.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as other courts, including federal courts?
Yes.
Do you understand that if you're not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just like a conviction at trial would? And this is true regardless of any advice by your attorney or anybody else.
Yes.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm or use a firearm in a crime, you'll be guilty of a felony, which may carry a sentence from 1 to 15 years in prison?
Yes.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following trial?
Yes.
For example, your guilty plea may affect the right to vote, to hold public office, to serve on a jury, to obtain a passport, to receive, possess, or transport a firearm, or impact your ability to obtain employment.
Yes.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury,
Yes.
the right to remain silent and not incriminate yourself,
Yes.
the right to confront witnesses against you,
Yes.
the right to the assistance of counsel hired by you or court-appointed counsel if you cannot afford an attorney at a trial of your case,
Yes.
the right to the presumption of innocence,
Yes.
the right to testify on your own behalf and to present other evidence,
Yes.
the right to subpoena witnesses and compel the production of evidence,
Yes.
the right to have the charges proved beyond a reasonable doubt,
Yes.
the right to appeal if convicted of these charges after a trial.
Yes.
Do you understand that you may only have a limited right to appeal this guilty plea conviction?
Yes.
Do you understand that you only have 4 years from today for a felony charge to file a habeas corpus petition challenging the voluntariness of your guilty plea?
Yes.
How do you plead to the charges in indictment 24 SC 003440 to 1 count of armed robbery, 2nd count aggravated assault, 3rd count possession of a firearm during the commission of a felony, and 4th count possession of a firearm by a convicted felon?
Yes.
Has anyone forced you, threatened you, or promised you anything to get you to enter a guilty plea?
No.
Is it your decision to waive these rights and enter a guilty plea because you're in fact guilty?
Can you repeat the question for him?
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
So that she wants to make sure that you want to plead guilty and that you understand that by pleading guilty, we're not going to trial.
Oh, yeah.
So
yeah.
yes. Mhm.
Yes.
Is this guilty plea freely and voluntarily given to you with the full knowledge of the charges against you?
Yes.
At this time, we'll provide a factual basis to the court on November 23rd, 2023 at about 7:32 p.m. The defendant was at 1552 Donald Lee Hollowell Parkway. The defendant met up with the victim, Mr. Gregory Ruffin. They had been communicating via the phone for a couple of days. I believe they met at a MARTA station. They exchanged information. On the day in question, the individuals were supposed to get up and hang out. They went to American Deli, but it was closed. And at some point, Mr. Ruffin demanded that, Mr. Williams demanded that Mr. Ruffin send him some money via Cash App. Mr. Williams pulled a gun out on Mr. Ruffin and demanded that he dance, and was able to transfer the victim transferred about $134 to Mr. Williams' Cash App, which the officers were able to verify. Based on the information provided by the victim, the officers provided a lineup to the victim, and he positively identified the defendant. Judge, we are asking for a slight deviation from the minimum for this case. We'll probably hear from pretrial. He had some history, but not that much history. And so we are recommending a complete term of 15 years with 7 years to be served in incarceration.
And the balance on probation?
And the balance on probation, no contact with the victim, stay away from the location where the incident occurred, and any other terms and conditions that the court would apply.
Okay, thank you. Ms. Jackson, last case of the day, criminal history, please, for Mr. Williams.
Yes, there are 7 cycles. The last arrest was April the 5th, 2023 in Clayton County for a probation violation. He does appear to have an outstanding hold out of Decatur, Georgia for simple assault. The date on that warrant was May the 22nd, 2024. He does have a prior felony conviction. It's in 2022 for theft by taking, and he does have misdemeanor convictions. One in 2022 out of Clayton County for theft by shoplifting. An additional one in 2022 out of Clayton County for simple battery. Nothing in addition, Your Honor.
Thank you, and thank you for your help today. Ms. Simpson, is Mr. Williams on probation now? Okay.
His last case he had with us, which was 21 SC case, he had revocation and she closed the case out.
Okay. Got it. All right. Ms. Wood.
Thank you, Judge. Mr. Williams has actually been in continuous custody between Fulton, DeKalb, and Department of Corrections since his arrest here on January 10th of 2024. That DeKalb arrest that pretrial mentioned is actually from a jail incident, and so he will have to go to DeKalb County once we're done here to handle that business. Judge, I just want to highlight for the court, he actually had the Georgia Justice Project reach out to me last year asking me if he could resolve this before I had ever met him. So I just want to let the court know he has been eager to accept responsibility. He's 22. He's a lifelong resident of Atlanta. You heard he has a 10th grade education. He's just, ready to accept responsibility and move forward, Judge. So we would ask that you accept the state's recommendation in this case.
Okay. Mr. Williams, anything you want to add?
No, sir.
Okay. Mr. Williams, I find there's a factual basis for your plea. If this case went to trial and Mr. Ruffin testified consistent with what we've heard, the jury could find you guilty. Also find that your plea is knowing and voluntary. Voluntary means you've decided that this is the right way forward. No one's forcing you to do it. And knowing means you've understood the various things people have been talking about. Do you agree with that?
I do.
Okay, I'll accept your plea. I'm sentencing you pursuant to the Probation Options Management Act. So the part of your sentence that will be probation, if you have a little hiccup there, you'll see probation about it. But if you get arrested or something serious like that while you're on probation, you'll come see me. Ms. Wood, can someone in my office sign the indictment for you?
Yes, Judge.
And Ms. Davis?
Yes, Your Honor.
Mr. Williams, is it okay if we electronically affix your name to the indictment indicating your guilty plea?
Yes, sir.
All right, we will do that. I will follow the negotiated resolution. I will deviate downward a bit from the mandatory minimum for the armed robbery charge pursuant to 1710 6.1E. Your sentence as to count 1 will be 10 years to serve 7 with the balance on probation. Count 2 will also be 10 years to serve 7, balance on probation. Count 3 will run consecutive to count 1 and will be 5 years, it will be probated. And count 4 will be 10 years to serve 7, balance probated. 1, 2, and 4 all run concurrently at the same time. 3 has to be consecutive to count 1, which ends up with a sentence of 15 years to serve 7, balance probated. You'll get credit for all the time you've been in since this arrest. Special conditions of probation are 3. 1, no contact with Mr. Ruffin. 2, stay away from that location. Donnelly Hollowell was popular today. Stay away from that location on Donnelly Hollowell. And 3, get your GED. You can do that while you're in custody. If you do, you get out with your GED, you've already knocked out one of the conditions of your probation. Ms. Davis, anything else for the state?
No, Your Honor.
Ms. Wood
No,
for the
Judge.
defense?
No, Judge, thank you.
Okay. Then we are all set. Good luck, Mr. Williams.
Good luck. Judge, did we finish with Tyreek, Mr. Good on the position
No,
18?
he was on the call for a long time.
Did he drop off?
He did.
Okay, that's fine. It was not gonna be a plea.
Okay, so we should he's had his final plea and to put him on the trial calendar? Okay. And then Mr. Ross should still be up.
Yeah.
Can you just bring him to the door? Thanks. So Gould is a move to trial calendar. Elder is a plea next week. Hey, Mr. Ross. Good afternoon. Sorry to keep you waiting so long. I was hoping your attorney might be able to make it, but she is in trial and can't be here because she is in front of a jury. So 2 things about your case. 1, we can't do the final plea hearing today, which would be a conversation about are you working it out? And if not, what are the consequences? 2, I learned today that Ms. Cabrera, who is your attorney of record, she's the one listed in the system, confusingly is also the attorney for Ms. Bernard, who is a co-defendant in your case. And that doesn't work. You have a lawyer who just represents you, doesn't represent anyone else. So when Ms. Cabrera is done with the trial she's in, we're going to need to figure out, does she stay with you or does she stay with Ms. Bernard? If she goes to Ms. Bernard, we will get you your own lawyer. You won't be at any disadvantage, but that lawyer will need to get up to speed. So that we don't lose any time or traction, I'm going to keep your case on the July trial calendar. That's 1 month from today. We're back here to see, are we going to trial or what? That'll just keep you moving with the other 2, although one guy just pled, so it'd be keeping you moving with Ms. Bernard. Between now and then, we'll figure out about who your lawyer is going to be. And then if we need to tap the brakes because you're getting a different lawyer so that person can speed up, we'll certainly do that. But I wanted to let you know the reason why you didn't come out here for anything is that Ms. Cabrera is stuck in that trial. So we'll sort out representation, get you back here and figure out which way we're going. Any questions? So at the latest, July 10, that's the trial calendar. But I don't want you to panic if you haven't met with a new lawyer and it's July 10th. You're not going to have to represent yourself at trial. We wouldn't do anything like that. We'll have the right lawyer for you before then. And it may still be Ms. Cabrera. We'll figure that out. That lawyer will meet with you. And at the latest, on July 10th, we'll figure out where are we going with Mr. Ross's case, because he's been sitting in jail and we need to figure out what's next. Okay? All right. I'll see you soon. All right. Let me end one thing. Pardon? I am. I'm just going to say bye to the gallery.